Ladies and gentlemen, this is Bruce the Moose in Wisconsin with your video for the evening. It is, what is it, Wednesday, 4/22/26. Today, what are we doing? We are going to go over the motion to dismiss and alternatively, motion for summary judgment in the matter of a member of the State Bar of Arizona, David S. Gingras, before the presiding disciplinary judge. And we're going to get into that. And we may have a special guest joining us tonight. So let me know in the chat what you're up to, what kind of beverage you have and everything. Today, we are joined by a guest cat as well. Our guest cat today is Captain Twizzler. Captain Twizzler has a snorkel and a fez and a raw steak. Clearly he's been busier than I have on a Wednesday, but that's where we are, guys. Let's see what's going on in chat. Smash the like button. Sarah is here. Big Tiff Dog is here. Ms. Wings, Lisa B, and IB. All right. Okay. So we've got some time to burn before my special guest arrives. So I thought, hey, you know what would be a good primer for the first 10 to 30 minutes of this video? Since we're going to be going through the motion to, where's my volume? Here we go. Since we're going to go through this motion to dismiss and alternatively motion for summary judgment, what a name. You know, these things get, you're really in the thick of these court filings when they have names like respondent's response to the respondent's first response of the third motion to compel lunch. I mean, then you're getting deep. This one's, it's something. But I thought what we could do first is switch over and let me see if I can find it. How I do this. I think I have to take this down because I want a different window. Okay. And I want, add it back to the stage. No, what I want is, I have to share my screen a second time. I want a different window because we're going to go look at an AI summary. I asked Claude Sonnet 4.6. Jeep Daddy will love this. I asked it, what is Arizona's anti-SLAPP law? Okay, because we come in here and it's like there's a SLAPP law, there's an anti-SLAPP, a SLAPP and an anti-SLAPP. And if you put the two together, you get antimatter and black holes form and swallow up the universe, right? So what do these things mean? Let's get into that. And I can take this comment down. Well, who else is here? Oh, Bacon Bears is here. That's nice. What is this? Bacon being naughty? No, never. I don't think so. Echoes is here. Echoes. Oh, wait. Oh, Echoes is definitely being naughty about something. He could just be talking about, a Wisconsin bratwurst. We don't know. Anyway, I asked Sonnet, what the heck is Arizona's anti-SLAPP law? Because this is the context we need before we get into this legal document in greater detail. Okay. So here's what we got. What SLAPP means. SLAPP stands for Strategic Lawsuit Against Public Participation. The idea is that powerful entities, corporations, governments, wealthy individuals, that rules me out, sometimes file meritless lawsuits, not to win, but to silence critics by burying them in legal costs and stress. Okay. Like maybe a certain Blake Lively filing a subpoena on Lauren Knighty, for example. I don't know. Anti-SLAPP laws are designed to stop that. Okay. Arizona's law. Now, this is interesting because there are very specific details relevant to Arizona in here that I think will be relevant for our court document that Mr. Gingras has filed. All right. Arizona's law is ARS 12751. I keep leaving comments up on the thing. What am I doing? That sounds presidential. I mean, I'm not presidential. Hello, hello. Blora? What do you I don't know. Chat is just gonna run itself, I think. How does one file a slap motion? Okay, I think the idea is that you file anti-slap. Okay, so the idea is like the slap is the thing you want to not happen. But let's read the definition and see. Okay, so the anti-SLAPP laws are designed to stop that. So you want to take advantage of the anti-SLAPP law to protect yourself. Arizona's law is ARS 12751. Arizona first passed an anti-SLAPP law in 2006, but it was narrow. It only protected people petitioning the government directly. The 2022 amendments, which took effect September 24th, 2022, so well before this Owens v. Echard Owens v. Echard paternity case, marked a substantial expansion of the law's scope, now protecting all lawful exercises of First Amendment rights, including free speech and free press. Okay, very good. How it works in 3 steps. Number 1, the defendant files the motion. The SLAPP defendant must demonstrate that the case against them was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. That's Gingriss's burden here, showing that the bar is retaliating against his protected speech. Okay. Number 2, the burden shifts to the plaintiff. So I think to answer Bacon Bear's question, it's basically this motion that I had pulled up at the beginning that we're going to read through tonight, or at least hit the highlights of, depending on how much time we have. Number 2, the burden shifts to the plaintiff. If Gingras makes the showing, if the plaintiff is a state actor, which the bar is, presumably, they must show their claims are justified by clearly established law and that they did not act to deter, retaliate against, or prevent the defendant's exercise of constitutional rights. Okay. This is a higher bar, making it easier to win anti-SLAPP motions against the government. All right. Number 3, fees and appeals. If the court finds that the defendant has shown the case was improperly motivated, the court's decision granting or denying the anti-SLAPP motion can be immediately appealed, meaning Gingras doesn't have to wait for the whole disciplinary proceeding to end before taking this issue up. Okay, so let's see if we have questions about that. Let's see. You file a motion for fist fight. Oh no, we don't want to do that. Let's see. So said we missing this. Have a presentation. Oh, you got to do your homework. Don't skip the homework to be on the YouTubes. Oh no. Let's see what else. Big Tiff saw it says I'm not blue. Oh, we got to fix that. Okay. I'm dying to know how bad today's depo was. I am pity anyone dealing with Jingy. I think this guy has a deposition tomorrow, Thursday. I think it's tomorrow, not today, but I could be wrong on that. Let's see. Echoes says, I hope there is deposition audio. Okay. Big Tiff Dog says tomorrow. Okay, very good. All right. It did the Sonnet 4.6 did a little bit of analysis here, which is nice. And it says the law's weakness, relevance to this case. The odd provision requiring speakers to show the lawsuit was substantially motivated by a desire to abridge speech limits the effectiveness of the law. This is Gingras's hardest hurdle. Proving the bar's motive was retaliation rather than legitimate discipline, even if the charges are weak. So if the bar is saying, hey, we want to sanction Gingras because of these multiple things that we'll get into, there's a list of about a half dozen that they originally brought up. Even if you consider those to be weak charges, Gingras with this anti-SLAPP motion still needs to prove that they had some sort of desire or were substantially motivated to abridge his speech limits. And I don't know how you do that without some sort of, text messages or writing that infers that that's the case. I'm not sure how they do that, but we'll read the motion and see. Arizona's anti-SLAPP law also contains separate requirements for plaintiffs who are state actors to show their legal action is justified They must satisfy one of three requirements, such as demonstrating the present legal action is consistent with a track record of pursuing similar legal actions against unlawful actions. Oh my. This is exactly why the motion hammers so hard on Woodnick not being prosecuted. And this is an interesting point because last night when I was on Lauren's channel and we were talking about some of this and these ideas that it's sort of a whataboutism when you're reading it from the point of view of a member of the public, right? Uh, it feels like Gingras complaining about the bar not bringing sanctions against Woodnick is kind of like somebody who's getting a speeding ticket and saying, "Well, the red car next to me, the blue car, was going just as fast as me, and you didn't give him a ticket." I mean, the bigger problem is uh, if you zoom out from the specifics of this paternity case with Gingras and Woodnick, it's not about individual cars or individual lawyers. It's about does the bar, uh, sanction lawyers in Arizona at a consistent level, or are they trying to sanction Gingras inconsistently relative to the baseline of all of their average sanctions? That's my take on that. So this is kind of interesting. And it gave me a new perspective here. It directly attacks the bar's ability to meet that track record requirement. Yeah. So he's not zooming out. He's still zoomed in on the Owens v. Echard case. And he's just saying, hey, I think Woodnick did something sketchy, but you're not doing anything about him, but you're doing this stuff about me. To me, the bigger question is the Arizona bar doing something to Gingras that is out of the ordinary relative to other cases where they've sanctioned lawyers? And that's a question I don't know the answer to. So that's why I find watching these things interesting. Okay, the bottom line for this case, and then we'll get into the filing. The 2022 expansion is what makes this motion possible at all. The old law almost certainly wouldn't have covered a bar discipline proceeding. The fact that since Arizona anti-SLAPP law was amended in 2022, there have been no published decisions applying it in state bar discipline cases. This means this is genuinely new legal territory, which is both an opportunity and a risk for Gingras. So that's interesting too. And I think, to me, when I started to see more of this motion work in this case beyond the original charges, some of these things to me became kind of interesting because we're in uncharted territory to some extent. Okay, now let's go back to the motions. Man, you really have to click a lot of weird buttons here. It's fine. Everything's fine. Okay, very good. Now we're back with the motion here, and let's see if there's questions. In chat, Bacon Bear says, I wonder if he writes about Woodnick in his diary. Well, I mean, I think his law firm blog effectively is his diary. He's writing in it very often. So I think the answer is yes. Oh my goodness. Yeah, let's see. What else? There's the hype button. Yeah, I don't know how the hype button works. Why can't we hype me? I don't know. I'm too boring. You can't hype me. Big Tiff Dog says he argues law so badly. I mean, I haven't been convinced by a lot of his motions. Personally, it's fair. That's fair. Let's see. He's in love. He loves being humiliated by Woodnick. Oh boy, trouble. Yeah, I mean, the aspects of this relitigating the paternity case, I think go a little bit too off the rails. And let's see. So many didn't make the naughty list. Next time, Echoes, next time we're gonna I need a black chair. I have my IKEA chair. I was sitting in it earlier today thinking things. But anyway, let's get into the motion before us. And hopefully it's sometime tonight in a few minutes. by the time we get through the introduction, I think we might have a special guest, so that'll be good. Okay, so pursuant to ARS 12751, Arizona's anti-SLAPP law, which is why I went off and asked what that is, because it's like, let's set some context. Respondent Gingras respectfully moves for an order dismissing this matter with prejudice. Ooh. And dismissing it with prejudice would mean they can't come back and try the same thing again. Dismissal is required because the complaint contains claims which arise from state and federally constitutionally protected speech, and petitioning activity and the state bar cannot meet the burdens required by ARS 12751B. Respondent further moves for an award of costs, including attorney's fees and damages, including lost income, in an amount to be established by affidavit pursuant to ARS 12751F and 12353. I would be interested to see what that lost income is, because as far as I know, the guy was doing Laura Owens' appeal work for free. So I don't know what lost income he had. He did the Hey Rob IAH, and I don't see how he lost income there. He did that case. So that's interesting. Who knows? Maybe he was trying to line up a flooring gig, a tiling gig, and couldn't do it because he had to work on this case. I don't know. In the alternative, and solely if the court finds ARS 12751 inapplicable for any reason, respondent moves for summary judgment pursuant to Arizona Rules of Civil Procedure 56. Summary judgment is proper because no material facts are disputed and respondent is entitled to judgment as a matter of law. Okay. So, yeah, make this whole thing go away and give me some money. That sounds fair. Respondent is aware the PDJ recently issued an order granting judgment. Let me move my window around a little bit here so I can see the chat is still alive and we don't fall sideways. Okay. Respondent is aware the PDJ recently issued an order granting judgment on the pleadings with respect to a single issue. That order did not mention nor did it resolve respondents' defenses under ARS 12751 or the Arizona/US constitutions. And I think this is going to be very important. I was reading through the comments on Reddit about these filings. And one of the interesting things there is kind of, it may be that this motion isn't going to go anywhere because there was already an order granting judgment on the pleadings with respect to at least one issue. So if that alone makes this motion to dismiss or this motion for summary judgment moot, then the only value in it would be the value for its appeal potential. So if they appeal to the Arizona Supreme Court or the U.S. Supreme Court down the road. So that's an interesting thing to think about. To preserve those issues, this motion will raise those arguments. So exactly, they're putting this stuff on the record now, even if they think it's going to be dismissed. Okay. Even though the court may consider them to have been resolved by the prior ruling. Okay, so an introduction. What is this? You saw a vanity plate jingy. Oh no, that's something interesting. So happy to see another moron in the world blames YouTubers and the public for the result of their stupid behavior. Oh no. YouTube made me do it. I don't, what did I do? Anyway, what else do we got? The hype feature is restricted to long form videos. Okay, well, that's good to know. Don't believe the hype. TX Packet wants ice cream. Don't we all? I mean, you can never not want ice cream. Okay, introduction. In this case, the Arizona bar seeks to discipline David Gingras for activities that are protected under the right to free speech and the right to petition. The bar's position is inconsistent with the First Amendment. But even if it were, the Arizona Constitution would not tolerate the bar's position. Okay. So they're saying that even if it wasn't protected by the feds. Arizona itself would be protecting them. The Arizona Constitution provides broader guarantees than the First Amendment. Okay, that's nice. The words of the Arizona Constitution are too plain for equivocation. The right of every person to freely speak, write, and publish may not be limited. And here we have a case about looks like telephone companies, newspapers, and more newspaper press association. Okay, rejecting a gag order of the type prohibited in this case, but 10 years before that decision was decided. Nevertheless, even if this tribunal were to ignore the Arizona Constitution's higher level of speech protection, the First Amendment and Gentile versus State Bar of Nevada and its progeny would roundly reject the bar's position on this matter. This case arises from a high-profile paternity matter called Owens v. Echard. Oh, don't remind me. This case drew immense public attention because the respondent in that case, Clayton Echard, is a former TV celebrity who appeared on the reality TV dating show The Bachelor. As is common in such high-profile cases, it drew an army of spectators. Oh boy. Not just in person, but online. This online morass of attention. A morass. Guys, you are a morass. Can you believe it? Of attention and harassment. Well, now that's a bold claim. I don't know who's been harassed. I don't think you should lump an army of spectators in with any harassment claims. This is a bridge too far for me. I don't agree with this. Created a bit of a circus. Oh no, a bit of a circus. I don't know if it really created a bit of a circus. I mean, whenever you have a litigant in the legal system, a high-profile litigant, there's going to be coverage. There's going to be people that want to follow the case, see what happens. Echo supports more ass. Well, this is not only antlers. This is moose crime time. Oh boy. Sign up for my only antlers and you can see all the moose feet pick and antlers you want. Okay, anyway. As is common in such high profile cases, right? We have the online morass, we have the harassment, we have the circus, and appears to have excited the judge. Wait, what? What does this even mean? It appears to have excited the judge. What? In what way? This is crazy. Who did not appear to handle the public attention with the greatest degree of care? Like, why not? I mean, there was court security, there was extra court security, there was an overflow room, there were escorts for the litigants to their cars and back. What care did they not handle? This is very strange. Okay. See request for judicial notice, Exhibit 105 at pages 17 through 37, the affidavit of David S. Gingras in support of petitioner's notice of change of judge for cause, describing pretrial and post-trial issues. And last night, of course, on Lauren's channel, Court of Random Opinion, we read through some of the bullet points in this document. I think it's pretty long, but maybe I'll do like a pre-recorded video where I read through the whole thing on that bad, Larry. We'll see how far we can get. Respondent, okay, in representing his client, determined some of the judge's actions were tainted. Oh, not the taint. As long as it's not a tattooed taint. Okay. That would be too much. Okay, respondent representing his client determined some of the judge's actions were tainted. I mean, I don't know if determined is the word I would use. Speculated? Yeah, exactly. He determined? Like, who is he to determine? He can question or speculate. He can investigate for evidence, or he can show the evidence he found or something. But I mean, I don't know. All right. I take umbrage with this. Okay. For example, okay, we get examples, guys. The judge made a finding of fact that was not based on any trial evidence, but was raised on social media after the trial ended. And of course, if we're talking about the sentence where the what is it, the final ruling, where they say, "Oh, someone said Planned Parenthood is closed on Sunday." Um, the the sentence where it says the Planned Parenthood is closed on Sunday is, if you say it's a finding of fact, I mean, it's not a finding of material fact for the conclusion of the case. If you said, "Hey, all the LA Planned Parenthoods are open on Sunday," and you put that in the ruling, would it change the outcome of the ruling? I don't think so, because the outcome of the ruling was not decided upon based on a particular Planned Parenthood in LA being open or closed, because we never saw a sonogram from that location. And ladies and gentlemen, as we're in the middle of the introduction of this document, we are joined by special guest, LOL Cal Lawyer. How are you doing, sir?
Hey, Bruce. Good. How are you?
Oh my gosh, hold on. You are coming through my external speakers. I'm going to fix that real quick.
Gotcha.
Okay, that sounds a lot better. Okay, perfect. All right. So I don't know if you saw any of the video up until this point.
No, but I did watch the one with you and Lauren last night going over the affidavit.
Okay. So where I started was, because this is the motion to dismiss. Okay, we're down here. Where are we? We're on like page 3. Because this is pursuant to ARS 12751, Arizona's anti-SLAPP law. I went
Correct.
over and asked AI to give me a good definition of Arizona's anti-SLAPP law, and I went over that.
Yeah.
So let's start over with that from your perspective. What if you wanted to explain to a layperson, what is the SLAPP? What's the anti-SLAPP? What does it all mean? What's the TLDR definition from your perspective?
Yeah. I mean, I learned a little bit about it, about the Arizona specific statute, just from doing, anecdotal research on this. So there is a unique aspect of Arizona's anti-SLAPP statute that we can get to later. It's not actually applicable here, despite what David thinks, um, to a certain extent. But the way that I understand it, and I'm sure the way most of us understand it, is that it is a defense that a civil or criminal in Arizona defendant can raise to basically say the reason that I'm being sued is to like stifle my right to free speech. So it acts as a shield in a sense that you can raise it as an affirmative defense. And then it also acts as a sword in the sense that it provides for damages if it is found that the lawsuit was, the term is substantially motivated by
Right.
wanting to stifle your speech.
Mhm.
But it's a two-step process. So it's gate one, the gate you have to step through is to show that the lawsuit is substantially motivated by wanting to stifle your speech. So, and then after that
Yeah.
gate two, then it flips it back over to the government or whoever's suing you to prove actually, no, it's not, I'm not suing you because of your speech. I have independent reasons besides what you're saying, such as, like if yelling fire in a movie theater apparently is no longer like a violation of the First Amendment, but it's the example we all know. So, if
I've
I'm
heard it's
yelling,
not a great example anymore.
yeah, I think I think maybe yelling like bomb on a plane is probably more of an
Oh,
example.
jeez. Yeah,
Yeah,
definitely don't wanna do that.
yeah,
That has actionable immediate consequences for sure.
yeah. There's an actual law. Like, so if you violate, so it starts getting a little complicated. But like, let's say there is a law on the books that says you can't yell bomb on a plane. If you then yell bomb on a plane and you claim you can't put me in jail or you can't sue me because I am exercising my First Amendment right and anti-SLAPP protects that, the judge is going to look at that and say the law that you're complaining about, like the judge has to weigh the interests in what the law is compared to what you're complaining about to
Mhm.
see, is the law that is being used to prosecute you something that um, is fits within the bounds of like curtailing people's speech, or does the law appear to sort of be they would call it narrowly tailoring. So I'm sorry, I'm going on a complete rant at this point, but um anytime that we deal with the Constitution and constitutional violations, the standard of review is by and large strict scrutiny.
Mhm.
Strict scrutiny is a two-part test. Basically, the behavior that is being, um, like, I guess, what would the word be? The behavior that is being punished, it
Mhm.
is the law is as a substantial interest for the public, and that the way that the law is written narrowly enough that it just protects that interest.
Mhm.
So overall, I would say anti-SLAPP is a pretty powerful tool. I would think in David's case, this is just jumping right into predictions, but I think in David's case, the Rachel Mitchell ruling recently that he was talking about, I think that actually does sort of work in his favor because the anti-SLAPP statute was found to be constitutional, but I think what's going to be hard for him is that there is no law in Arizona that says that it applies to bar discipline proceedings. And
Mhm.
so if I'm the judge, I'm more likely than not going to play it safe and rule that it doesn't apply, because in my head I'm thinking the people who really should be deciding this are the Supreme Court of Arizona. So
Mhm.
my prediction is that the judge will deny it, but not because David is flat out wrong, but just because there's no precedent for the judge to interpret how to apply the law in this context. And then when it gets appealed,
Mhm.
then we'll really have to see, like, does the Arizona Supreme Court believe that it fits that bar discipline proceedings fit within the anti-SLAPP statute.
Yeah, that sounds
Okay.
good.
Sorry
I
about all
think
that, guys.
yeah, I think you really explained a lot of these things that the AI summary was trying to give to me. They actually
Hmm,
mentioned the same thing you just did, s since
hmm.
this, Arizona anti-SLAPP law was amended in 2022 to broaden it, right? Its opinion was that the original, what was it, 2006 or something, the old law wouldn't have covered a bar discipline proceeding, but this one is untested. No published decisions applying it in state bar discipline cases means it's new territory, which I think is what you
Yeah.
were alluding to.
Yeah.
So,
Absolutely.
yeah, and I think it hit your two-step process, right, where the defendant files the motion and needs to show that there was this desire to prevent the lawful exercise of a constitutional right. And now tell me, how does someone do that? Because to me, I don't know how to prove that another person had a particular desire unless they like wrote about it and then I have that piece of paper where they wrote it. What is are there other avenues to prove this or
Well, it's the standard is substantial motivation.
Mhm.
So if I throw a rock and it hits a car windshield and it breaks the windshield, and the question is like, what was my substantial motivation there?
Mhm.
Maybe there's evidence that the person's car, I didn't like that person, I had a grudge against them. but maybe there's also evidence that there was like someone trying to break into the car.
Mhm.
And so you have to stack those coins of like what makes us think that this was motivated by trying to shut you up, and what makes us think that this wasn't motivated by trying to shut you up.
Mhm.
And the way the state's going to do that is really by ensuring that you get due process, and that that you're being heard, and the points that you're raising are being thought of in a meaningful way. But if we apply it to David's situation, the substantial motivation, like he has not followed this analysis. Like there is no there. I mean, we're gonna read it, but I'm pretty sure there is no section where it says these are the substantial motivations. It's just sort of what I said is protected by the First Amendment, so I win. And I'm not sure if that's because he believes it's so obvious that the motivation was substantial, like was substantially to retaliate against him. But he's got an uphill battle. Like independent third parties filed the complaint.
Mhm.
That shows that it wasn't on the bar's own initiative, except for maybe there was one. Um, the bar took a year to investigate it. They didn't just go right after him. The ethical rules that they charged him with violating are clearly not rules designed, like they weren't enacted because of David. They've been on the books.
Yeah.
So I have a hard, unless there's something we don't know about where Jim Lee is like says to David, like, fuck you, I want to shut you up.
Yeah.
Like then I don't know where he's going to get that evidence, but that is the evidence that he would need to present in for the first step.
Yeah. One of the other things from the AI summary was about, the consistency. Like, why is Gingras constantly bringing up, why aren't you looking at Woodnick? Right.
Well, there you go.
It,
Then that's a great connection. That actually could be a scintilla of evidence of substantial motivation. But the thing is that he needs to stack those coins sky high. Like you know what I mean?
mhm. Yeah, my take was really, Gingras, he's got this narrow view, which I don't know whether it's right or not, of the paternity case. So he's bringing up Woodnick, he's bringing up things from the paternity case. Whereas my reading of this,
Free David.
my reading of this, the weakness he has here is that he would sort of need to say, what has the bar historically done in terms of sanctioning all the lawyers in Arizona if they've been sanctioned? And are they trying to sanction Gingras at a disproportionate level versus maybe the average? Whereas I think what he's arguing is, hey, look at Woodnick. So it's sort of like the analogy I used was a speeding ticket. If I get a speeding ticket, I can say, well, the red car next to me was also going fast, but you didn't give them a speeding ticket. Nobody's going to buy that argument because we all know they give out random speeding tickets, right? It's just sort of they're not focusing just on you in the blue car. They may
It
have
certainly
missed the red
feels like
car.
that to
Yeah,
people. Yeah.
they may have missed the red car, but it doesn't mean they're missing everyone and that they're doing something disproportionate to you.
Yeah. And a big issue for David is that that Jim Lee cited multiple cases where people have been treated the same as him, where
Mhm.
they
Okay.
have been disciplined for saying disparaging things about judges. But
Mhm.
this is why these First Amendment cases, like, I don't know, I just come from a different legal world than David, I
Yeah.
suppose. Like where
I think
I
everybody does.
I believe in rolling up my sleeves. And so like what I would have done to accumulate evidence to show that I was treated differently
Mhm.
is not what David has done. And I'm trying to be careful because I don't want to give him any ammunition or like any advantages in his treasure hunt for the Holy Grail.
Yeah, you don't want to do free work, right? You should at least get paid if you come up with some good ideas. Um, let's see. Are we on page 2 or page 3? I was just reading through the introduction. I don't know if you've read this already and there's specific sections you want to focus on tonight
Well, the
or
one I can tell you the one thing I wouldn't focus on is
mhm,
the disparaging comments about Mata because
mhm,
it's moot. Like, in my opinion, him including a discussion about the things he said about Mata
mhm.
is contempt of court. Like, there was a
Oh my.
there was a decision by the judge, right? The judge ruled on that issue,
Mhm.
and then he just bulldozed forward to to discuss it anyway. So it just shows contempt for the court and not really honoring what the rules are for them.
Yeah. I'm trying to find where they mention this. So, is that the part of the case that already had an order granting judgment on the pleadings? Because it
Yes.
says respondent is aware the PDJ recently issued an order granting judgment on the pleadings with respect to a single issue. And my take on this paragraph or what they're saying here, right? To preserve the issues, because they're talking about the Arizona or US Constitution, the motion will raise the arguments, even though the court may consider those to have been resolved by prior ruling. My interpretation of that is they're putting things on the record in case they want to do an appeal in the future at either the Arizona Supreme Court or the US Supreme Court level. What do you think about that?
I mean, he already did that in his response to the bar's motion for judgment on the pleadings.
Mhm.
So, you know, judges do have, I mean, it's going to come down to whether or not the PDJ agrees to strike those portions of the motion where he does argue about Mata. And I think it would be proper for the judge to do so because it has been ruled on. So it's an inappropriate place to have this argument. Um, but, if I'm a judge, I'm gonna tell my clerks, "Okay, read both of them, but, like, I want separate memos I want separate analyses on both of them, and maybe, like, let's see what the analysis of his response to the motion for judgment on the pleadings is, and if maybe there's any holes in there, maybe I'll consider the motion for summary judgment argument, but I'm not. Uh, I would probably be considered more of a liberal judge. If you get a stickler who is like, no screenshots on the page, then the judge. Then you already know the judge is going to follow the rules and is not going to make any exceptions.
Yeah.
But in terms of starting this, I feel like we all know the facts, so I
Mhm.
would just
Mhm.
start it at the discussion section. And I'm
Yeah.
a top down guy, so
Yeah, I had gotten through let's see this part. I was in this paragraph here. Respondent in representing his client determined some of the judge's actions were tainted. And I took umbrage with this word determined because I don't think I think that's a little strong language for me anyway.
I
Uh
mean, he could have determined it for himself.
yeah.
It doesn't mean that it's accurate. I mean, a lot of this is hyperbole.
Mhm, mhm.
My dad calls it a hyperbole for effect, and I just call it being
I
an
see.
asshole.
Hyperbole for effect. Okay, very good. And that I think when you came on, I was talking about the Planned Parenthood being closed on Sunday, made a finding of fact. And the question is, if he's saying here the judge made a finding of fact, to me, it's the Planned Parenthood being closed on Sunday is not material to the ruling or the case. Does that change whether you call it a finding of fact or not? Or is it still called a finding of fact because it is a sentence in the judge's final ruling?
If memory serves, the judge's ruling was it numbered? Like each paragraph was numbered?
Oh my gosh.
I can't recall off the top of my head, but
I think
all to say
so,
that
but I don't recall 100%.
there is usually a findings of fact section.
Mhm, mhm.
And then after that is the analysis. So if
Oh,
this was stated in the finding of fact, then I would consider it a finding of fact. But if it was stated in the broader discussion, it's more. of like an analysis than,
Oh, I see.
like a conclusive finding of
Mhm.
fact. But I mean,
I mean, it was a very long document, right? So the
yeah,
findings of fact could have been, hey, non-paternity and fees,
that
and
would be conclusions of law,
right? Yeah. Okay.
because those are
All right.
legal conclusions that, you
All
know,
right.
fees and non-paternity. But then the
Mhm.
facts would be, she failed to honor her discovery obligations. Like that would be a finding of fact.
Oh, I see.
Yeah,
Okay. All
yeah.
right. Very good. All right. Let's see. This was raised on social media after the trial ended. I mean, okay. And the great amount of attention by anonymous trolls on Reddit,
A
a,
notorious online cesspool.
a notorious online cesspool. Wow, that's so rude. I mean, Reddit to me is what you make of it, right? You can follow the topics if you just want to follow knitting and like cocktail recipes, you can just follow knitting and cocktails. You don't have to, I don't know. There may be some subreddits that are cesspools, but this is really, I think you said it's hyperbolic, right? Led respondent to describe them as fucking assholes, not in court, but in a private email. Now,
Sent on his law firm's email address.
that's what I wanted to ask you about is like what is the barrier here between a lawyer doing their personal, like I got to go do my laundry at the laundromat, or I got to go like get a new credit card at the bank, versus doing their lawyer work while they're representing a client. And to me, this is kind of in a gray area because yeah, he's talking about his YouTube channel with Google, YouTube, but the topic of his channel is his case with his client, and he's CCing his client on the email. And so there, where is this?
I think this is why this motion and the affidavit are purposefully vague in the parts that are not beneficial to David. And I've
Mhm.
actually talked to David about this. He doesn't know that I have, but my point was, um, it's fine to advocate for yourself, but part of being a lawyer is also acknowledging the facts that are not good for you. He typically does it by saying, "In all fairness," which I don't even know what that means, but but like with by not providing the full context,
Mhm.
when he said, "It's not my job to provide the judge with full context. It's the judge's job to look into the record, and it's opposing counsel's job to make that argument." And I'm like, if that's how you want a lawyer, that's fine, but you're really harming your credibility with the court if someone does call you on your bullshit one day, and it turns out, wow, you completely painted this with rose-colored glasses for yourself. It's going to really damage your credibility to the court. So you're always playing with fire when you're writing like this. But to your original question of, it was this the engaging in the practice of law. The reason I raised like the intentional vagueness is because I feel like if you don't double click into the situation, you could just see it as he was trying to shut up some trolls on Reddit, and he sent an email to Reddit on his own behalf, and he was used some foul language. But if you double click into it, then you're like, wait, he used his work email address. Wait, it was about uh, a client he was representing during the representation. It was in furtherance of something that he may have used like as evidence in court of blah insert. So I I respect government employees. I work with a ton of them, but they are so overworked and
Yeah.
so underpaid
Mhm.
that the level of resources and attention to detail and time that I'm not 100% convinced that they are going to have the time or the resources to,
Mhm.
one, do that research, and two, to be able to convey that to the judge.
Yeah.
Not really through any fault of their own. But that's why I think that him keeping it purposely vague like this, um, if Jim Lee reads this and doesn't do any further research and just tries to argue against his facts, that's the pitfall that
Mhm.
you're going to run into. You can't
Mhm.
argue against his facts because all his facts are the most favorable to him. You have to do your own independent analysis, and that can be really hard to do when you've got family. I was literally at like I have nowhere near as much stress or work as a government employee, and
Yeah.
I had 30 minutes before I got home from work to get on the Zoom. So I can
Yeah.
only imagine what their
The
lives were
bar.
like.
Yeah, and I mean, when I worked, I did a stint for the state of Wisconsin,
Mm,
in a government job, and to me, the bureaucracy was like a boat anchor
yeah.
almost in terms of even if you did have some passion for something, like sometimes there's just not enough hours in the day because of the bureaucracy and
Yeah.
all of that.
Yeah.
Um, okay. All right. In a private email. So then he says, this is
Oh, I'm
maybe,
sorry. Let me just conclude with
oh, yeah.
I believe that it
Mhm.
was the practice of law.
Oh,
Be
I see. Okay.
Specifically because of
Mhm.
what you raised yesterday, that it was related to the underlying court case, and then he blogged about it later, like
Yeah.
in furtherance of defending his client.
Yeah, his video and the videos he was complaining about and the things these people on Reddit are all talking about are the case.
Oh,
Exactly.
Bruce, you froze. Could be me.
Uh-oh.
Nope, you're back. You're back.
Okay. All right. I am in the basement. I don't know how good the signal is down here.
No, you're
But
good. You're
anyway,
good.
yeah, exactly. It's pretty crazy. Yeah, Reddit was talking about the case. His video talked about the case. The video he's complaining about talked about the case. Um, the posts that were doing breakdowns of his videos were talking about the case. So yeah, in what has become this is my favorite sentence, by the way. In what
Okay.
has become a proceeding Kafka would consider too far-fetched to believe. The bar charges respondent with 6 different acts of misconduct during Owens. And I actually I made ChatGPT make this into a table, but it's right here. Number 1, Violet. And let's go through these 6 and you tell me which ones you think are, sort of the worst for Gingras and which ones are maybe the least worst for him. Violating an order which allegedly required information to be filed under seal.
That one, if I'm subject to change, if 1 is the worst for him and 6 is the least worst, I'd make
Okay.
that 6 right now.
It's the least worst.
Yeah.
Okay. And yeah, so my follow-up question on that is the sealing order says something like let the record reflect rather than it is ordered. When you hear that, is that a big enough distinction? Is it legally significant? Um,
David has overcomplicated this issue so much. If I
mhm,
hear that and I'm new to the case, I email Judges Chambers and I'm like, hey, can I get some clarification here?
I
That's
see.
all I do.
Yeah. You don't make up your own decision.
Yes,
Okay.
exactly.
And then
Exactly.
part 2 on that, there's this argument that Woodnick did the same type of thing. How much weight do you give to that? I gave it very little weight because what I saw from what Woodnick was doing was that the parties were sharing the discovery and then the parties were writing motions. And I think the thing that he was complaining about in terms of Woodnick's filing was part of a motion or something supporting an argument in a motion. Whereas what Gingras did was to take a whole entire document and just put it on Twitter or his blog.
I don't know why he keeps bringing up Woodnick's behavior because it's
Yeah.
not an affirmative defense. It's a
Okay.
mitigating factor.
Mhm. It's not
Uh, I
dispositive.
shouldn't be punished. I shouldn't be like the book shouldn't be thrown at me because look, other people have done this. But it's not a defense. We
Yeah.
would have to go to, and this is an issue I'll get to later. We have to go look at the rule that this is alleged to have violated
Mhm.
and see is there a defense to violating that rule? Is one of those defenses someone else did the same thing? Like,
Mhm.
no, that's not in that rule. So I
Yeah.
don't I don't find, and there's case law in Arizona that I've read that says the person who's being tried is the person who is subject to the complaint, not anyone else.
Right.
So pointing the finger at someone else, one, is just fucking childish, but two, it's not an affirmative defense. An affirmative defense would be it was too vague. And he did make that defense and the judge agreed, and that's why it got denied for judgment on the pleadings.
I see. I see. Yeah.
So that's six.
Okay, very good. Number 2, asking law enforcement to enforce a valid restraining order issued by a California court.
I'm gonna put that in the safe 3 area because he was told so many
Yeah.
times that but he's got a lot of, I think he actually has some valid defenses there for his actions.
Mhm. Okay. Number 3, making disparaging comments about the trial judge, Judge Mata.
Yeah, I think that's number 1 because
Oh,
his conclusions, he makes this point about if the facts underlying the conclusion if the facts underlying his comments are true, then he can't be punished. So he's saying the fact that there's nothing in the record that shows Planned Parenthood was closed on Sunday is a true fact. The fact that but then it goes off the rails from there. Then it's like
yeah.
he tries to say the fact that Judge Mata must have done independent research, like there's no other conclusion. That's not
Yeah.
true.
Right.
That's not a true underlying fact because he
Mhm.
doesn't know it to be true. So his conclusion is based on inferences versus facts.
Yeah.
So one.
Okay, very, very good. And then, I know that Judge Mata, going back to number 2 for a quick second because,
Mhm.
damn it said that's witness intimidation. Judge Mata said didn't go as far as to call this witness intimidation, but where do you land on that in terms of this, number 2?
Well, again, we have to go back to what ethical rule this was considered to have violated. And I
Mhm.
believe the ethical rule this is considered to have violated is to act with integrity and candor towards the court and the public.
Mhm.
So, witness intimidation is that's a conclusion of law that what the
Okay.
actions that he did amounted to witness intimidation. But the
It
behavior,
it could be a conclusion if that was a process. We're not on that process though, right?
right,
Just
we're
to be
just
fair to him, it's that hasn't been done as a conclusion of law.
right, right. It's just, and I don't think the bar has alleged that he intimidated a witness. It's the underlying conduct. All we care about here is the conduct.
Mhm.
Was the conduct was David's conduct prejudicial to the administration of justice? In that situation, if you have the judge telling you he can testify, if you have the record showing that he was served with a valid subpoena, if you were told by multiple law enforcement agencies that they couldn't do anything, even if
Right.
you believe that this violated a federal statute,
Mhm.
you've been told by multiple people of authority that you're wrong. And
Yeah.
so to continue to double and triple down is prejudicial to the administration of justice. You're spitting in the face of um, the, I guess in the case of police, the executive branch, and in the case of the judge, the judicial branch.
Mhm. Mhm. Very good. All right. Because I think this is one that really it sort of hits the public, but it has a different sort of context in the legal domain. Like
And
this is an emotional one for the people watching the case, but we have to set the context in the legal domain separately.
yeah, I mean, I think the fact that Michael felt intimidated led him to file the bar complaint, which led the bar to investigate it. And the
Mhm.
bar doesn't have the authority to say something was or was not witness intimidation, but they do have the authority to say this, whatever this conduct was, witness intimidation or other, it violated the the code of ethics for lawyers.
Mhm. Mhm.
I'm going to pull up the complaint so I know which.
Okay. And
We
then
can.
number 4, making disparaging comments referring to a group, that's us, as fucking assholes. Don't forget, it's total fucking psychotic assholes. We got to get it right. But anyway.
I'm gonna give that 5
Mhm.
because, I believe Jim Lee brought this up on his own, so
Okay.
there isn't a complaining party in the situation,
Mhm.
and it's kind of a toss-up as to whether or not David was engaged in the practice of law. I think it'll
Mhm.
really come down to how the judge interprets the situation,
Mhm.
but given what he's done already, he's already harmed his credibility with the judge.
Well,
So if go
yeah.
ahead.
Oh, no. My brain's like running on a different track. Jim
No,
Lee the Jim Lee can't just like, he's not gonna, um what is he gonna do? He's not gonna know that this email like, somebody has to complain about it, right?
I think
But
he put it in one of his filings to the court, Bruce.
yeah, but somebody must have complained about it to the bar originally. It must have been, like, a bar complaint from the public, correct? Because this guy racked up, like, what, 12 of these things? Like,
Yeah, he
somebody
racked up a
must
whole bunch.
it
Yeah.
must have come from somewhere, like, someone.
He mentioned a woman's name that I haven't heard before,
Mhm.
so I'm not sure if this was the situation.
Yeah, and it's so hard to tell because we only know specific bar complaints, like, from Judge Mata or Mike Maricini or Dave Neal, and if there are other ones, there are probably people that don't even wanna be mentioned if they were involved in, if there was some Reddit back and forth, if he was striking videos, these sort of things. Big Tiff Dog says he attached his email to his federal subpoena request. Okay, so maybe
Yeah,
maybe he just told on himself here.
Oh, he's told on himself multiple times.
Okay, so it could have gone either way. But in any case, yeah, I kind of agree with you. I think this one's kind of low on the list because it's like, look, he can call me a total fucking psychotic asshole or whatever, and I'm not gonna, I don't know. My life's not over.
Okay, so the rule that conduct is uh, said to have violated, I found
Mhm.
it is coming up as wingdings. That's weird.
Oh,
um,
food font.
Arizona law 41B7. Duties and obligations of members. B7. Avoid engaging in unprofessional conduct and to
Mhm.
advance no fact prejudicial to the honor or reputation of a party or a witness unless required by the duties to a client or a tribunal.
Mhm.
So it's a two-part. It's one, avoid unprofessional conduct. I
Yeah.
think I think
That's
he's
clearly what, to me,
and
where
to
this falls.
advance no fact prejudicial to the honor or reputation of a party or a witness. That, I mean, you'd have to go into the case law to really understand what that means.
That
Um,
doesn't sound like it applies to this item 4 here to me.
yeah, it sounds like he's halfway there, but not all the way there because it wasn't really in furtherance of a duty he was. Well, again, it depends on how down the rabbit hole you want to get. Like Jim Lee is going to have to make that argument,
Mhm.
but my opinion is that I think Jim just like his complaint against David said no more than he needed to
Right.
because he was expecting the deluge that happened.
Sure. Yeah. This one, to me, I think it probably does land low in terms of severity, but to me, it amazes me that in these government positions, it's these sort of things like, the president or whoever using or whoever you whatever politician you like or dislike using their own phone or something, right? Or whatever. Like if somebody worked where I work and was using their personal device to do work stuff, they would just be fired, right? If
Yeah.
if somebody who reported to me at my job called another engineer a total fucking psychotic asshole, I would walk them out the door and take their badge 5 minutes later. I
Yeah.
mean, it's so it to me, it's just interesting that the bar seems to be the equivalent of his boss. And yet, what does
Def
it take to get this like, to me, there's so much going on here that if it was in my domain of private business, it would not be acceptable.
Well, let me push it even further because David actually has to pay the bar every year to
Mhm.
keep his license. We
Okay.
don't pay our bosses. So it's not even that it's analogous to he's his boss. It is the
Yeah.
regulator.
Yeah, it's more like his bar card is an entitlement, like a driver's license. You start out without it, and then you do something to prove you deserve it, and then you get it, and if you do something wrong, they can take it away. That's an entitlement, right?
Right. Yeah. Like I would think about it as like let's say I worked for a utility company and then I reached out to the government agency that regulates the utility company and I was like my coworker's a fucking asshole. Like one the utility company is going to fire you, but then two the regulator is probably going to investigate that and like that's
Mhm.
kind of what he was doing.
Mhm. Mhm. Okay, interesting. Okay, let's see. Number 5, pursuing meritless claims, presenting false information in an affidavit, and presenting Miss Owens' false testimony slash changing versions of events. Okay, so this one's interesting. What's your take on this one, number 5?
So this is a violation of ethical rule 1.3.
Mhm.
Um, I mean, I have a gut reaction, but
Yeah,
I just want to ground it in law first.
I see. Yeah, because the court of public opinion gut reaction is this is pretty high, especially for people who are following all the core details of the case, because I think we have an emotional reaction to seeing when we see these examples, like, "Oh, she had a feeling they were boy-girl twins." But then we hear in the Love Trapped podcast last week or the week before that there's this deposition audio where she says a provider told her it was boy-girl twins, and we see this inconsistency, and as a lawyer, he didn't report this inconsistency to the court, and examples like that, and then I think Lauren showed the other example. um, these things just hit us pretty hard, right?
Yeah. Like these are all very obvious things to us that
Yeah.
they were non-meritorious.
Mhm.
And so, I mean, I think that that's kind of gonna have to be the analysis the judge comes up with for this is was this willful blindness? And I
Mhm.
think that you guys have like the perfect hook for a nice, clean decision, which is that his primary motivation was notoriety.
Mm.
And so he was willing to turn a blind eye, and no one has made that argument yet for the bar, which
Oh, I see. Interesting.
which is unfortunate. I'm not sure if they've connected those dots, but I think that that's a nice, clean way of saying all of these actions indicate willful blindness. And the motivation for that willful blindness was in furtherance of his own personal agenda.
Mhm. Yeah, I mean, he came right out the gate making documented Twitter posts or blogs about how he wanted to do PR, or later on how, oh, I didn't do a good enough job of PR. And to me, I was always saying it's such a bad job or such a bad idea to mix the two jobs of
Yes.
PR and being a lawyer for your client because like we've seen, like Lauren's been covering in this Blake Lively, Justin Baldoni case, PR is this like sketchy, murky land of chaos where you're not totally honest and you're just trying to spin things and like
It's thin.
and whichever side you're on, PR is always kind of like there's a fixer somewhere trying to do something and like so to me, if you're going to conflate your job of being a lawyer with the job of PR, you're putting yourself in this position to be held accountable by these type of sanctions.
Yeah, yeah, and that's why, like, if you are gonna do PR, you really need to, like, stick to factual statements that are in the public record.
Mhm,
Um,
mhm,
and in this situation, for this one, I would put this at 2, because there are findings of fact that she perjured herself. She actually perjured herself
mhm,
on the stand. There was no notice of candor after the fact, and Ethical Rule 3.1 says that in bringing or defending a litigation, the lawyer has to have a good faith basis that in law that the litigation is not frivolous.
mhm,
And that's based on an objective standard.
mhm,
So
mhm,
David's only objective standard for this was not frivolous was Laura believed she was pregnant because she peed hot on an HCG test.
mhm.
But then there's this mountain of other evidence. You have the patient portal, you see that nothing has actually happened. You had like one thing that gobsmacked me was when they were sending over documents to MedChill, Laura said to David, let's not send him the sonogram I altered because it could affect my credibility.
Mhm.
And we have nothing in the record that shows David being like, no, we can't do that. It seems like that's actually what they did.
Yeah, I mean, they didn't send him anything she futzed around with,
Right. So I think that
presumably.
yeah, presume I
I mean,
mean,
he literally asks Dr. Medchill on the stand, "Did you make your determination based on any altered or, cooked
yeah.
data?" And
Yeah.
Medchill's like, "No."
Yeah. Yeah. So we know that so that email shows that he was aware of it and then purposefully chose to not give that information to the expert, um, which is suborning. I mean, it's misleading your expert at the best. It's
Mhm,
suborning perjury at the worst.
mhm.
But I think someone said it yesterday. It was either you or Lauren that by not filing that notice of candor after the changing testimony about Planned Parenthood, that
Yeah.
right there is to me conclusive proof of the third quote in this allegation, the false testimony changing version of events.
Yeah, exactly, and it's not the only example, it's maybe one of the better ones.
Right.
Yeah,
Right. Right.
for
So I'd
sure.
put that at 2.
Mhm, very good, okay. Let's see, number 6, pursuing a non-meritorious appeal. I think this is interesting to get your take on.
Yeah, I mean, again, it's gonna take the double clicking by the bar because they're gonna have to go on, the same Rule 26 odyssey we all went on, but
Yeah.
I think it can be disposed of pretty quickly by just saying the Rule 24 motion or 26, whatever it was withdrawn. It was no longer a live issue. It was deny like it was not even addressed in the sanctions portion in the remedy portion of the under advisement ruling, and so it had really no basis whatsoever for being in the appeal. It was done and dusted.
Mhm.
So when the term non-meritorious appeal is like an umbrella term for all of the issues, the only problem for David is one of the issues he chose to bring up on appeal was this Rule 26 issue.
Sure.
So I think, um, that I think this one has broader policy implications that may lead a judge to say, for policy reasons, I'm not going to find on this, because
Mhm.
you don't want to stifle the broader legal community's willingness to engage in good faith novel arguments.
Mhm.
And
Mhm.
that's the point of being a lawyer. Um,
Do you recall
so
it was
I
there
put this
any Yeah.
fourth
Yeah.
one.
Right, yeah. We were down there, bottom half.
Yeah.
Do you recall in the appeal, did he make any arguments outside of the Rule 26 domain? Because to me, if the entire appeal was only about Rule 26, then it has a much greater chance of, to me, being found non-meritorious. Whereas if he said, "We're appealing because of A, B, and C, and one of those is about Rule 26," maybe it's less non-meritorious to me.
Yeah, I'm looking it up. I'm looking up what the grounds for appeal were.
Mhm.
But, there's a lack of of specificity that is a David hallmark that makes it
Yeah.
hard to really. I mean, I guess there was it's not complicated, it's just dumb. Like, what did Mata rule on? Like, Mata ruled, it seems like she ruled that Clayton, a finding of non-paternity for Clayton,
Mhm.
and a finding that the case was brought in bad faith, and so attorney's fees were warranted.
Mhm.
Um,
And a referral to the county attorney.
yeah, I don't know if you can appeal that.
Oh, yeah, yeah, that's not,
That was just a
presumably
referral.
that's not an appealable issue.
All right, let's see. Appeal, amended notice of appeal, Court of Appeals order. Hmm. Ruling, case status, petitioner, change of judge. It's weird. The appeal is actually block. It's not here.
It's alright, we can think about
Okay.
it.
Okay.
Um,
I found it.
alright, let's see. Okay, so we talked before another question, I don't know if we really wanna read this whole document or anything, but, I definitely wanted to sort of get an intro, understand anti-SLAPP, and get your take on the bar charges that they are sort of attacking here with the motion to dismiss or the motion to anti-SLAPP.
Well, maybe now that we've done the depth chart, we just look at the discussion around. I said number one was Mata. I don't think we need to look at that. So maybe we look at
Mhm.
the number two, which I think I said was
Oh, yeah.
um
There was a second one in your priority list. Was it number 5? It was number 5, right?
yes. Yeah.
Mhm.
Yeah. Let's look at that one.
Okay. And of course, they say none of these claims have merit because of course they will. They say 1 through 4 are about speech and conduct, which is protected by the First Amendment. So that's 1 through 4. Okay. And then 5 and 6, they say are demonstrably false. And prosecuting respondent for claim 6 is a violation of the right to petition, which is sort of what we were talking about before, right? You don't want to discourage people from making arguments on appeal.
Yeah.
Um, so that's fine. But I think it's interesting here that they lump 5 and 6 together and say they're factually false, which we can argue. And then they specifically call out 6 as being a troublemaker the way you did, but they don't say anything about 5, which I think hints at its importance or ranking that we came up with. Um,
Interesting. I
yeah.
mean, that typically is a sign.
Trying to
And then, by the way, I just looked up the appeal.
Oh,
David
yeah.
did raise on the appeal
Mhm.
Rule 26, which was
Mhm.
not an appealable issue. So on issue one, meritless. Issue 2, did the judge commit structural error by conducting an investigation? I also consider that frivolous because it was never proved, and the presiding judge disagreed.
Yeah, it wasn't substantive to the ruling. So why are we talking about it? It's a don't care. So I agree.
And then issue 3 was, did the judge err by awarding sanctions? I think that that's a fair appeal, like whatever, that's a colorable argument. He was
Mhm.
trying to say, he didn't incur any fees until blah, 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 whatever, like fine. For issue 4, did the trial court err by awarding legal fees? So it's issue 3 and 4 are redundant. Issue 5, is Laura entitled to fees and costs on her appeal? I don't think that's an issue.
Oh boy.
So I would say issue 1 and 2 are
Mhm.
meritless,
Mhm.
groundless, and frivolous.
Mhm.
Issue 3 and 4 are redundant, but probably based on some type of decent argument. Issue 5 is completely irrelevant. So if we're going for a if we're the more than the preponderance of evidence shows that the majority of the appeal
The
is true.
majority of it is jank.
Yeah.
Okay. All
So he
right.
really doesn't discuss the 5 and 6?
Oh, well, not in this follow-up paragraph to the list, but
Mhm.
this is a big document. This is a big document. So,
Yeah.
let me see if they break these down in sections actually. Preliminary discussion of ARS 12751. Okay. I don't think we need that. He's got arguments. Okay, I think this is where we need to break these arguments down. So you've got the sealing order. You said we didn't need to discuss that one. Oh boy.
Actually, this is structured better than his usual writing.
Well, my take, this is the Randazza legal group. And my take is we've already seen some goofy quotes, but we haven't seen anything to the level of like, look at me, daddy, I'm a real judge now. So if the Randazza legal group can tamp down DSG and make these filings a little more organized, I think they're worth the paycheck. In any case, I'll find this section. Okay, here's number 2. Respondents' public comments did not violate ER 3.6. Okay, is this the calling people assholes? What are we talking about here? Oh, I think this is the MATA. Okay, and we got Mike Maricini. They've organized it a little differently. Okay, Mike Maricini. Let's see if we talk disparaging comments about the public. I demand an apology. Demand an apology on behalf of Dave Neal. Pursuing meritless claims, presenting false information in an affidavit, and presenting Ms. Owens' false testimony. This is the section we want to take a look at, I think. And you're muted.
Yes, let's look at this.
The 5th issue involves allegations that Ms. Owens offered fake testimony and that she changed her story slightly. I always look for these LY words.
I literally control FLY and then delete the words when I'm done writing.
Jack Fox would be proud. As the
LY
case was
and
pending.
that.
Yeah. These claims are described in some detail in these paragraphs of the complaint. Of course they are. The disposition of this claim is extremely easy to resolve. Oh,
Okay.
no, we've got an extremely easy. Like, this is the thing I always hate in these things. Don't tell me, like, about the thing. Tell me the thing. Do you know what I mean? Like, I don't want to talk about talking about something. I just want to talk about something. Because the bar has because the bar has no evidence of any kind to support the alleged misconduct. This, and I think, this is what Lauren was trying to do last night in her stream was present evidence to counter this argument. This is, yeah.
This just upsets me because he goes from the bar didn't present any evidence to support the alleged misconduct. The next thing a lawyer should do is, this is the alleged misconduct, and these are the facts that the bar presented. Instead, he says this thing he has a hard on for about the rule being amended. It just doesn't serve any purpose
Okay.
in
Yeah.
in the situation. And his conduct occurred like the conduct is evaluated at the time it occurred,
Mhm.
and the conduct occurred before this change happened. So I don't know
Oh.
how they're gonna deal with that. I mean, there's a whole like class you can take on whether or not laws are retrospective or prospective. And there's no you'd have to really look at like the legislative history
Mhm.
to know. But there's no indication whether or not the change is prospective or retrospective.
How do you determine that?
Sometimes the laws will say it. I mean, definitely in like criminal cases. I It's been so long since I've answered that question. The only way I've done it is to go into the legislative history or to look at like prior iterations of the law to see if there's any indication. Um, but no, I mean, until it's applied, there's no way to know if it's retrospective or perspective. I guess I can try to look it up, but it would take too much time, and I probably would not get everyone the right answer. So
Yeah,
I'm not
we're
gonna.
not you're not getting a paycheck for that.
Yeah.
Yeah, 'cause this is interesting because I wouldn't have noticed this if you hadn't pointed it out, where they say, "This is so because in August 2025, the Arizona Supreme Court issued this order, 2529, amending comment 8 to ER 3.3 to clarify the standards that govern the presentation of false evidence. The comment explains in detail what a lawyer can and cannot do when faced with the possibility that a client has not been truthful." And I think that's what we were trying to point out on the stream with Lauren last night. Was he faced with these situations where he had conflicting evidence? It certainly seems like there's a couple. The full comment 8 to ER 3.3 now states the prohibition against offering false evidence only applies if the lawyer knows that the evidence is false. A lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact.
I
Will
mean,
these two sentences conflict with each other? I'm confused. The prohibition against offering false evidence only applies if the lawyer knows that the evidence is false.
I think knows is actual knowledge, and reasonable belief is like a little bit based on speculation.
Okay, so these two sentences differ because one says knows and one
Mhm.
says reasonable belief.
That's what I flag. That's what I flag.
Okay. A lawyer's knowledge that evidence is false, however, can be inferred from the circumstances. Can be inferred.
Mhm.
Oh boy.
Mhm.
S This is very complicated. CER 1.0F. Thus, although a lawyer should resolve doubts about the veracity of testimony or other evidence in favor of the client, the oh geez, it goes on. The lawyer cannot ignore an obvious falsehood. Okay, wait. Although
I
what?
think that situation where it's like person A says it was raining, person B says it was not raining. If
Mhm,
that's all you have,
mhm,
then it's okay to believe your client that it wasn't raining. But if you have person A, B, C, and D being like, she lied and she has a pattern of this behavior, and then you have
mhm,
person Z, aka Laura, being like, I didn't lie. It's like,
mhm.
is is there reasonable doubt about the veracity of the testimony?
Oh boy. What if Laura says one thing under oath and then tells Gingras a different thing?
Oh,
Like it's not
um,
there's no person A, person B, it's just his client. His client says two things that are inconsistent, once to him and once, say, in a deposition.
and then if he were to offer as evidence what was said in the definition, knowing that it was not correct based on the subsequent private conversation, that'd be a violation of the first sentence. It'd be actual knowledge that the evidence was false.
Mhm. Mhm. Okay. I just have a problem with this giant sentence here because there's sort of this comma here, and I feel like this should be 2 sentences almost. But anyway, because it says, "A lawyer should resolve doubts about the veracity of testimony or other evidence in favor of the client."
Well, doubt is like if if the truth is 100%, doubt is like 80%. But an obvious falsehood is like
Oh, sure.
1% of this makes sense to me.
Mhm, mhm, mhm. I mean, a doubt could even be less than 50,
Right.
um, to me.
Yeah.
So, even if it's not, presenting false evidence to the court, I
And
guess
his
my
affidavit
yeah,
says, "I had doubt about what she said,
yeah.
but I followed it up and her mom said it was true." So that resolved the doubt. I don't know. Again, that's for the trier. That's really for the trier of fact, and it's really on
Yeah.
the bar
Mhm.
to like one of the things that made me laugh was how David was saying that the indictment was conclusory without mentioning the like pages and pages of investigative reports that were released where where Jan flat out lies like multiple times.
Oh,
Like
boy.
so um you know,
Yeah, it's very strange. I think, oh, what was I gonna say? My next question is really keying in on this word "should." Like, what is this word this isn't like "must" or "shall," it's more "should." Should sort of implies to me,
use your best
you
discretion.
should, but if you didn't.
Yeah. And I think that this is inviting consideration of the broader context
Yeah.
of the stonewalling of the discovery, of having multiple attorneys, of um, have it changing her story within the deposition itself, of changing her story
Mhm,
during trial.
mhm.
It's like, at what point are you just being willfully blind?
Correct.
And I
Yeah.
think that David and Laura have being willfully blind has worked for them because people just
Mhm.
don't wanna deal with them. They're like,
Right.
"Okay, whatever. You're lying, but, like, whatever. Like, it doesn't affect my life." But
Yeah.
now they have a whole system and people on Reddit
Mhm.
who are not gonna let them get away with, um, being willfully ignorant. So they're being held to a standard they're not used to being held to.
Correct, correct. Yeah, and I think the frustration I think why this count out of the 6 is interesting to me is because, uh, a lot of people, like, when we're in Lauren's stream last night, I think Lauren and other people, they want, like, a machine, like an Excel spreadsheet. If you put the inputs in, you get an output that says whether Gingras is guilty or not of these charges.
Mhm.
And what you're pointing out here is that it's not that simple. You have to have, a trier of fact apply human judgment.
Yeah, and not only that, you have to have someone who is willing to provide the judge with the counterpoints.
Yeah.
It's kinda like how Clayton was like, "I didn't even wanna answer the complaint, but then I was told if I didn't answer the complaint, I would lose." It's
Yeah.
like, and that's what makes David's type of lawyering so frustrating is that he puts people in a position to have to do more work while he himself does the bare minimum, like, makes conclusory statements, and just sort of shifts the burden back onto the government. But at the same time, being like having like a libertarian soul, I'm like, if the government is going to impede on my life, then I do
Mm.
want them to have to prove everything that they say.
Yeah, you wanna respect, innocent until proven guilty, right? Even in not just criminal matters, but other areas of life.
Yeah, yeah, absolutely. You like I don't want the um government to be able to just say I did something and have it be true. Like that's
Hmm.
they should have to prove their burden. But um he just makes it a lot harder for them. Which, hey, I mean, honestly, if the choice is between saying nothing and saying a bunch of bullshit that muddies the water,
Hmm.
like, I don't know. I think it really comes down to character. Like,
Hmm.
I feel like the person who is saying a bunch of bullshit is sort of has that character of, I'm gonna see what I can get away with, versus
Yeah.
someone who doesn't say anything is like, it's up to the court to prove these charges. I'm not gonna
Mhm.
help them. I'm just gonna present my facts and that's it.
Yeah, and I mean, those are 2 ends of a spectrum, you could go anywhere in between.
Right, right.
Uh, okay, and then they continue with the what was this called? This was Comet 8 and 33. Oh my gosh. The lawyer cannot ignore the obvious falsehood. If a lawyer reasonably believes that evidence has been materially altered or generated with the intent to deceive the court, the lawyer has an obligation to conduct a reasonable inquiry before submitting the evidence to the court. The scope of the inquiry will vary according to the circumstances of each case, but factors to consider may include the probative value of the evidence, the value or importance of the case or issue, the source of the evidence, and what, if any, accessible, reliable, and affordable tools or methods are available to assess the evidence's authenticity or integrity. If after inquiry the lawyer still does not know that the evidence has been materially altered or generated with intent to deceive, the lawyer retains discretion to submit the evidence to the court. Okay. And of course, they don't include in here what the non amended comment is, right? We don't know
No, and
how it
again, I
was
think that
amended.
yeah, I think that that's intentionally misleading. I mean, at the very least, if you were gonna include this, you should at least opine on why you think it applies retrospectively. But he's not gonna do that,
Mm.
he's gonna make the bar do that.
Oh, boy. Based on these standards, respondent is entitled to summary judgment as to this claim because even assuming Ms. Owens was not truthful at some point, even assuming, I think we can. Okay. The bar has no evidence to show respondent actually knew that. The bar's implied argument the respondent should have known the truth misstates the legal requirement of actual knowledge, knows, which we saw before, denotes actual knowledge of the fact in question, emphasis added. Okay, here the complainant claims Miss Owens offered testimony the bar claims was false, and the complainant claims respondent did not take any steps during direct or redirect examination to address Owens' false or inconsistent testimony. Um, which I think if they're talking about the,
Inferred.
LA Planned
Mhm,
Parenthood thing,
mhm.
or the, what was it? I saw Dr. Higley last Friday or Dr. McCool last Friday. That was another big one, I think. It was
Yeah.
very obvious at the time of the hearing.
Yeah, I mean, she started crying and they had to stop the hearing. Pretty obvious, and that's such a good point because he could have gotten up there on redirect and clarified that.
Yeah. Okay. Despite these allegations, the complaint merely claims Ms. Owens made one statement at a time and then later changed her story. The bar appears to allege this proves respondent knew Ms. Owens' first statement was true and her second was not. I don't think that's what they're alleging. I don't
Well, he has,
I
hung his hat
appears.
on the actual knowledge prong of
Yeah.
comment 8. And so
Mhm.
he's taking us on that journey, although those facts don't fit his situation. Like, he's not going to, well, maybe he will later on the inferred part, but this is all related to actual knowledge. So this is, this is a compelling argument because there is no smoking gun, even though I'm sure there probably is.
I just feel like it's a little lazy to say things like, the bar appears to allege. We know what the bar alleges. You can just quote it, right? Like, you don't have to say they appear to do something. This just
By
this just
by
seems like goofy arguing to me.
by the way, the comment 8,
Yeah.
the bar specifically stated that it doesn't become effective until January of 2026. So
so
this is actually a completely improper argument to make.
this whole thing could just be yeeted if they decide it's not retroactive. Is that what you're saying?
No, I'm saying
Or this part?
because the law became effective
Mhm.
in January of 2026, it is prospective. It's not retrospective.
Yeah.
The comment only applies to conduct that happens after January 2026.
Right. So if that's the case, then what I'm saying is then this whole section here just becomes useless, right?
And there's also an Arizona law that says that if a law is going to be retrospective, it has to be explicitly stated in the law.
Oh, that's very good.
Yep.
Specificity is good. Yeah, being specific, not saying the bar appears to allege.
Right.
It bugs me so much. The bar, and the other thing is, I don't know when the bar says that the first statement, which statement? We don't even know what statement we're talking about because they don't put it in here. They're just being so vague. And I don't know that the bar is saying the first statement's true and the second is not. I don't think the bar is making claims about the truth of the statements. I think the bar is just saying there's enough inconsistencies to warrant, right, a lawyer doing this due diligence, according to probably whatever the original comment 8 would say in it.
I think original comment 8 puts him in the drink.
Oh boy, that's trouble.
Yeah.
Okay, yeah. So this one's a doozy. Okay, we got the Judge Motto one, and this one's these are our troublemakers. Okay.
Not only is it a doozy, it's I can't believe Randazza signed his name to this. Randazza did not know, I hope, that comment 8 was not effective during the time of the conduct, because that is not okay. That is intentionally misleading the court to use this as argument.
Yeah, it's another one where you're either coming across as disingenuous and like, snake-like, as Megan Fox would say, or you're just dumb. And we don't think Randazza is dumb. So what's happening here? Is he just not paying attention?
I think he was misled by Gingras.
Yeah.
And to Tiff's point, yes. I mean, anytime that you sign up to be on a case, you are assumed to have encyclopedic knowledge of the case, unless you state otherwise and ask for more time.
Right.
But yeah, ignorance is not a defense. But again, David just has not ever been tested to this level before. People have just wanted to just not deal with him.
Okay. All right. The argument is simply not logical. If a witness offers testimony and later changes it, that may mean the witness intentionally lied, or it could simply mean the witness realized the initial statement was wrong and thus a correction was required. So they made a mistake. So here this is rich. To me, this is rich, not from a legal perspective, but just from Gingras likes to go on the blogs and the videos and say, Dave Neal lied and Megan Fox lied and Omar lied and Lauren lied. He just likes to throw out that everybody's lying about everything. And he never disambiguates it from a mistake or speculation or an opinion or anything like that. But in this filing, he'll do it right here and say, maybe Laura intentionally lied, or maybe she just made a mistake.
But what you're pointing out, Bruce, is great impeachment evidence. Like in his testimony, if he
Uh-huh.
gets up there and makes like there's nothing stopping Jim from saying you know, so is it your belief that if someone makes a statement at one time and makes another statement at another time, it could simply mean that their initial statement was wrong? And yes, well, what about when you said this? Well, what about when you said this? What, you know, so that's all impeachment evidence.
Trouble. In this case, one of the bar's main allegations is that during her deposition on March 1st, 2024, which took place, he loves to talk about how things were before his time, which took place before respondent representative Ms. Owens. She said she visited a Planned Parenthood location in Orange County, California. Then at trial on June 10th, Ms. Owens claims she went to a different Planned Parenthood locations in Los Angeles, not Orange County. Los Angeles and Orange County are directly adjoining. I don't know why that matters.
And isn't it irrelevant because he had her patient portal for Planned Parenthood and saw she never went to either?
Yeah, yeah. The fact that Ms. Owens changed her testimony means that one version was incorrect. Well, or both.
Or both.
So this statement is not even correct
Right.
because they could both be wrong.
Yeah, there's no alternative there to what you just said.
Yeah. But the state bar does not explain which, nor does the bar have even a scintilla of evidence to show respondent knew which version was correct and which was not. I think, to me, the point is not determining the absolute truth and absolute falsehood of a bunch of options. To
No.
me, the problem is you are aware of inconsistent statements from your client over time. And
Right,
you
because
you don't
you're operating under the second clause of that rule, which is the clause that fits the facts of this situation. David is operating under the first clause, which does not fit the facts of this situation.
yeah, like the answer can be I don't know, but I'm getting a bunch of conflicting information. I don't know if any of it is true, but I at least should know that it is all inconsistent because he should have had the deposition transcript. So things like Laura told me she had a feeling they were boy girl twins, or, you know, Laura said she went to Orange County. And then on June 10th, she said she went to LA. You know that you are receiving through the casework
Yeah.
inconsistent information. And
Yeah.
to me, that's the problem, not whether or not if you line up any alternatives, determining exactly which are true and exactly which are false.
And not to mention the fact that you can't go under a pseudonym. That
I mean,
was in the Dr. Dean's report.
oh, the Dr. Dean's one. Oh my gosh. It bugs me so much that he just tries to debunk Dr. Dean's with a dumb Google search. But
Trying to get into his head. I mean, maybe if what he's saying is if I take Laura's statement and then instead of comparing it to like a constellation of the contradictory evidence, if I just compare it to one piece of evidence at a time, I can side with Laura every time. And that's how I reach my conclusion of I believe her, I'm going with her. Like,
mhm,
okay, I'm comparing what Laura said to what Dr. Dean said. I believe Laura. I'm comparing Laura, what Laura said in to Clayton to what Clayton said here. I'm going with Laura. The
mhm.
problem is that that is not how context works.
Yeah. And to me, the bigger problem is even if you take all those instances and just give him the benefit of the doubt and say, okay, side with your client.
Hmm.
My point is, he is receiving through casework contradictory statements from his own client. So it's not like person A versus Laura, it's Laura versus Laura.
Right. I know. I was going to give that example, but then I
I
was like,
mean,
wait, it's the same person.
yeah, but she demonstrably gave different statements to the record and to her lawyer over time. And to me, that's where he's getting in trouble in this item.
Honestly, what I'm doing in this situation is I'm saying, listen, I've now that I've cracked open the case, I can't tell what's true or not. So either we're going to do a polygraph or I'm walking.
Do those things even work? I don't like,
Probably
why would
not on
one.
Laura 'cause she's so anxious and her blood pressure is probably all over the map given her current health situation. But I mean, if I wanted to stay on the case, if I would have enough to say I'm sorry, like
Mhm,
I can't resolve these issues,
mhm.
and your mom has an inherent conflict of interest to side with you, and so I can't even really take your mom as like an objective point of confirmation, and so like
Yeah.
I gotta walk. Like
Mhm.
unless buttons can talk, like I gotta walk.
Oh, yeah. Buttons can't talk. Buttons just has a good nose. Can sniff it out. Um, let's see.
Justice for buttons.
Let's see. What else do we got here? Okay. Respondent denied that allegation in his answer, and he has supplied this court with an affidavit stating under penalty of perjury that the bar's allegation of the complaint is factually false. As such, the bar now bears the burden of offering admissible evidence to prove a genuine factual dispute on that issue. But the bar has disclosed nothing to support this false allegation. Yeah, it's sort of like he wants the bar to go line up everything and enumerate it as like which ones are false and which ones are true. And I don't think they even have to get that far. But anyway,
Well,
he
he already introduced the entire Owens v. Echard docket into the case,
yeah.
so the evidence is there in the case.
Oh boy. For that reason, respondent is entitled to summary judgment on that issue. Obviously, comment 8 to ER33 indicates the lawyer's knowledge that evidence is false can be inferred from the circumstances. ER 1.0F provides knowingly, known, or knows denotes actual knowledge. A person's knowledge may be inferred from circumstances. It does not appear that the Arizona Supreme Court has published any authority regarding the correct standards under which a lawyer's knowledge of falsity may be inferred. But clearly, the answer cannot be based on nothing but pure speculation. In that case, any lawyer
Straw
involved in
man.
any yeah, this has nothing to do with this case. In that case, any lawyer involved in any case in which a client made a statement and then later changed it would always be exposed to career-ending discipline. Since the standard here is clear and convincing evidence, the bar cannot be allowed to make such a serious claim of wrongdoing based on literally nothing but sheer conjecture and speculation. I mean, they don't have only sheer conjecture and speculation, so
I mean, that's a
this is
very zealotous argument that's concludes this would get you a C minus in legal writing in law school.
yeah, I mean, the problem is it's a lot of words to sort of pound your fist on the table and say, like, this should all be dismissed because it's all just wrong. But
And
you haven't proven to me scientifically that it's wrong because you haven't cited the actual complaint evidence. Like saying that nothing but sheer conjecture and speculation, like they didn't bring charges based on nothing.
yeah,
So this is just wrong.
a panel found probable cause, so
Yeah.
it's already based on more than conjecture and
Yeah.
speculation.
So this is just wrong.
Yeah.
So this whole paragraph to me becomes I just don't buy it.
Well, that's because if you engaged in an analysis of the entire context of the situation that could lead to inferring that he knew she was lying, it doesn't look good for him. So
Mhm.
he's sort of stuck with this argument.
Oh boy. Yeah. The
And I
fact
wouldn't
is
even call it an argument. He's stuck with this statement.
yeah. The fact is supported by decisions from other states. Oh, no. Don't you love it when he goes to other states for his, case citations?
Yeah. And
Uh,
and this is where I think he's actually really fucked because if there is no case law on it,
yeah.
then I think the safe thing for the judge to do is find him guilty on it and make him appeal, and then the Supreme Court can make law if they want to.
Ooh, interesting. Yeah. The fact yeah, there's a lot of reading between the lines you have to do, like, why is he looking at decisions from other states? Oh, is it because yeah, we could go to the Supreme Court, which have the same ethical rules. For example, in Heron, a lawyer was accused of making a false statement to a court regarding the amount of time his client had tested clean for drugs. Oh boy. At a status conference, the lawyer informed the court his client had tested clean for 16 weeks. In truth, the actual amount of time was 11 weeks. Uh oh. Based on these facts, a hearing panel found the respondent had been dishonest with the court. Okay. On review to the Kansas Supreme Court, the lawyer argued his statement was based on a miscalculation, so he made a mistake, and he specifically cited language in comment 8 to Kansas's. We're in Kansas now, guys. I don't think we're in Kansas anymore.
I don't think we're in Arizona anymore.
In comment 8 to Kansas's version of ER33 that was identical to Arizona's. And, this is another thing, like that. I don't know if I believe this. Maybe it's true.
I don't believe any of it.
I don't believe it because previously in these appeals, they keep talking about how Rule 26 is identical to Federal Rule 11, and then everybody starts pointing out how it's not. I'm like, I don't believe you.
And regardless of whether the words are identical, the jurisprudence might not be.
Oh, that's interesting. So you're saying even if there's a rule or a comment in a rule and it's exactly the same, you're saying the precedential case law can be different.
Yeah. When I was on law review at my law school, I wrote something about circuit splits, which David has brought up before. And during that research, I found out that judges within the same district can have different rulings on the same issue, on the same law.
Yeah.
So the jurisprudence develops completely separate, from what the law is.
Interesting.
They
Okay.
have the same springboard, but different pool.
Yeah. Oh boy. Yeah, different splash zone. Let's see. A lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. A lawyer's knowledge that evidence is false, however, can be inferred from circumstances. Okay. The Kansas Supreme Court reversed the hearings panel, and we've already seen this may all be pointless depending upon what the original ER33 comment 8 was.
So I think 3.3 has not changed. 3.3 is just this thing that he's quoted up here, which is reasonable belief that the evidence is that's 3.3. The comment is just giving color to what 3.3. It's explaining 3.3. So I think 3.3 has stayed the same. The comment was just added.
Correct. The comment was modified. But this says cited language in comment 8, and then he has a quotation. So this is not just
so we're on like a second layer of bullshit.
This is not boilerplate 3.3. This is the comment 3.8 in Kansas. But anyway, it may all be irrelevant.
So then he is basing his use of the Kansas case on a statute in Arizona that was not in effect at the time of his conduct. Oh my, that is so sanctionable, David.
We have a couple steps removed here. Where this is a tenuous bridge. This is not a bridge I would want.
A good idea.
I would want a bungee cord before I walked across this bridge. This is something. The Kansas Supreme Court reversed the hearings panel finding of knowing dishonesty, finding the facts didn't support the charge. Even though knowing of falsity can be inferred, the court held clear and convincing evidence did not prove the lawyer offered a knowing falsehood, rather a faulty mental the guy's just bad at math. He should have had an Excel spreadsheet. And the charge was dismissed.
Can you go up again?
Oh, yeah.
It says the Kansas Supreme Court reversed the hearing panel's finding of knowing dishonesty. Okay, so we're bouncing back and forth between the knowing prong and the inferred prong. Okay. And he's citing Heron, which is a case discussing a comment that wasn't in effect at the time of his conduct and discussing a prong of 3.3 that does not fit the facts of David's situation. So that's really bad.
Oh, no.
That's just bad lawyering.
Mm.
I can't even think of an analogy dumb enough.
I can't tell you if it's bad or not. I'm just not finding it super convincing. I'm trying to have him convince me, and it's not working. But yeah, it's a little rough.
It's said with so much. Woodnick said it in one of the podcasts about Laura, how she can just so convincingly speak bullshit, and that's what this reminds me of. Speaking of the podcast,
Yeah.
I had an idea. Maybe we
Mhm.
can talk about it offline.
Mm.
But I was thinking, I wonder if chat would be interested in like us listening to the podcast and like commenting on it, like as we listen. Or, but usually, I mean, if anyone's like me, I like listening to it on my own, and then like I'll give it a second listen if I
Y
want. But
yeah.
I'd be interested if chat wanted to let us know if they'd be interested in hearing that, or if you guys just want to, enjoy it on your own. Because I heard 10 was supposed to be a banger.
A listening party is what you're saying.
Yeah.
I think
A reaction video.
Oh, reaction. Yeah, I don't know, it's interesting. I kinda think, I'm more of the, like, I listen to it, and then maybe the second time I listen to it, I take notes.
Right,
Like,
and then
this
I'm
is
saying,
what I
like,
do
that's
with
content, though.
Yeah, so going over notes would be interesting. I think literally playing it is, like, I don't know, it seems too, redundant to me, but,
Yeah, that's true. We
um
would have to check with Stephanie on the copyright,
yeah.
but I think we also have fair use. But IB brings up a good point there. I think really for me, I just wouldn't want to step on Lauren's toes because she's doing a Clayton Stephanie interview this week or sometime soon.
Oh, for this
So
week's episode? Yeah.
I will check
Mhm.
with uh, I'll check with the people that I think probably should be asked about that.
Like,
But
yeah, like, you know what I like? I like how Schnitzel Ninja interviews Stephanie
oh
about
my
each
god, I
episode
love those. Yeah,
and
if you
goes
guys haven't checked out Schnitzel Ninja's,
yeah.
behind the scenes interviews with Stephanie, she does a phenomenal job
Mhm.
at, you know, um, giving more life to the story. I'm not as,
Mhm.
eloquent as Schnitzel, so I would just love to be like, "Oh, shit, did you hear that?"
But I think it would be interesting to sort of say, "Okay, we assume everybody has listened to it," and you come in with your notes, and
Yeah,
you just sort of discuss your notes,
yeah,
and it's like,
that's
"Oh,
exactly it.
I didn't realize, here's 2 dots I connected." To me, that's the more interesting sort of thing somebody could do.
Yeah,
Um,
that's what I thought might be good content, but
mhm.
anyways, food for thought.
Yeah, for sure. Yeah, it's a great podcast. I don't know. They have then they have this Idaho case. I don't even know if we need to read it because it's
I
just
can do
like
it.
we.
I can read it.
Oh, do you
If
want
you
to
wanna
read
take
it?
a break.
Yeah.
Um, so if similarly, which is already scary. Similarly, in Doe, a lawyer was found guilty of violating Idaho's version of 3.3, which is identical to Arizona. The lawyer violated 3.3 by making representations to a court based on the facts contained in an unsigned declaration from a witness named Miller. The lawyer continued to make those representations for about a year, but it was eventually discovered that Miller had signed a different declaration containing different facts during that time period. The lawyer, Doe in this case, never disclosed this new information to the court. The Arizona Supreme Court found that there was substantial evidence to prove actual knowledge because the lawyer actually knew that he had two different declarations in his hand. The Idaho Supreme Court found there was substantial evidence to prove a violation of 3.3. This is so because Bar Counsel expressly found that Doe made false statements to the tribunal by continuing to rely on the unsigned declaration after receiving the smoking gun and representing to the court that Miller was unwilling to sign an affidavit when he had already done so. So, this is again actual knowledge, which is not David's situation.
Yeah.
Here, there are no facts to support the same result. Right, because we don't have any facts, because Laura will refuse. She's literally not going to take a plea deal because she can't tell the truth. The bar correctly notes Miss Owens changed her story, claiming in her deposition that she went to Planned Parenthood in Orange County and later changing her story at trial to claim she went to one in LA. Despite that change, the bar has no evidence, literally none, to show respondent knew which story was true and which was false. No one is fucking saying that, David. The
Yeah.
bar also has no evidence that Miss Owens ever told David that she planned to change her testimony at trial. So much ink wasted on the wrong syllable. Mixed metaphor there. Given these facts, respondent understood when Miss Owens changed her story at trial, this was done to correct a prior inaccurate statement.
Wait, so he is giving testimony about knowing which one's true and which one's false. He's doing it right here.
Yeah, he's basically saying at the time that I heard it, I then had knowledge that what she said in the past was a lie. So his state of mind at that moment
My
showed.
problem my problem is if in the past he didn't know, he's saying there's no evidence to show respondent knew in the past which story was true and which one's false. But now here today in the present, he's saying the second one is true and the first one's a mistake. How does he know that? Is
Right.
my question. Because
Exactly, but that's it. That's why we're not in the knowing situation. We're in the inferred through context situation.
oh boy.
So wow. I mean, takes balls.
Is he okay here? What's
I mean, honestly, this is something that I would spend a solid 20, 30 minutes on in the deposition. Like he's just
Yeah.
given this to Jim to like I'm pretty sure I could get him to change his testimony on this.
And I think it's not even this one. So there's the LA Planned Parenthood. That's just one. I think you could go through across all these cases, the IH, the OP, the paternity case, the affidavits, and you can find other examples of Laura to Laura inconsistencies that he should have dealt with.
Yeah, those are more facts to infer in the situation that your client probably isn't telling the truth.
Oh boy.
Because Miss Owens gave contradictory versions of events, the bar argues respondent was required to withdraw. But this is both a misstatement of the law and it ignores the fact that Mr. Echard also offered contradictory versions of events.
Uh-oh.
Okay, so maybe that is a decent fact to go to, like the context. It's like, well, everyone was lying to everybody, so like, but
yeah,
you know that doesn't absolve you from having to pick a side.
This this blows my mind. This example of Clayton lying that they give blows my mind.
Go ahead.
Oh, so it says, specifically on October 11th, 2023, Mr. Echard filed a petition for harassment injunction in case CV 2023 against Ms. Owens. In his original petition, Mr. Echard claims Ms. Owens harassed him by sending over 100 emails. And then there's a nice screenshot of him writing in here, defendant has sent over 100 emails. Okay, despite being blocked, also has texted me from 7 different phone numbers. I always found it interesting when Gingras was interviewing Laura and he's like, it seems like you've just had this, you've had a normal dating life or whatever. She's texting him from 7 different phone numbers. That's not normal, dude. But anyway, I digress. Every time I block one, she creates a new number. Later, Mr. Woodnick presented a materially different story. No, okay, materially. Is it materially different? This is the test, guys. This is the test. Let's go to math class.
Spoiler alert.
To the court in his motion for Rule 26 sanctions, respondent obtained an injunction against harassment against petitioner based on the receipt of 500 plus harassing messages. Okay.
Not emails.
Here's the thing. Here's my point. In math, okay, 500 plus and over 100 email is, if you say is 500 plus equal to over 100, more than 100, 500 plus is indeed over 100. So this is mathematically consistent. So it is not materially different.
I can actually make it easier than that, Bruce.
Okay.
Clayton says 100 emails, which
Oh, no,
is
he says over 100.
okay, over 100 emails, which an email is a communication from one email address to another email address.
Very good.
Woodnick says messages. Messages
True.
can be an email, it can be a carrier pigeon, it can
Oh,
be smoke signals,
a text.
it can be text.
Mhm.
And so I
A
don't,
DM. Mhm.
they are materially different in the sense that Clayton says over 100 emails, and then he doesn't quantify the number of messages. He just said the number of numbers.
Mhm. Mhm.
And Greg expands the statement
Mhm.
to be from emails to messages.
Yeah, so these you're saying there are two categories of things. So the two circles of quantity in the Venn diagrams are going to
Perfect.
just be inherently different, even though overall it's all consistent. It's these are two consistent statements.
Yeah.
If I say yesterday I went to lunch at Culver's, and then today I say yesterday I went to lunch at Burger King, I'm talking about the same thing, the same instance. My lunch yesterday, it was either at Culver's or Burger King. It wasn't at both,
Yes. Yeah.
assuming I had one lunch.
I think it's like
This is not a lie.
on this side is over 100 emails. On this
Yeah,
side is the harassing text messages. In the
yeah,
middle, that's
yeah.
probably 500.
Yes, yeah, or a superset or something. I
Yeah,
mean, we
superset.
don't know. The thing is, even if this said 500 plus emails,
Mhm.
the 500 plus emails is still over 100 emails.
Sure. Yeah, it's
So
inclusive
to
of.
me, it doesn't matter. So then they're like, if the state bar's position in this case is correct, then respondent was required to withdraw from representing Mr. Owens, Ms. Owens, simply because she changed her story and offered contradictory versions of events. And the same rule would apply to Mr. Woodnick. No, that's not.
No.
No,
No.
because you didn't do the math on these numbers. Oh boy.
And the laziness just shows again because
Mhm,
he had access to these communications, assuming he could have just, and I mean, I've been a first year associate before. I have had to sit and count emails.
mhm. Yeah. Yeah, if they were sitting there saying like on March, Ms. Owens sent 20 emails to Clayton, and then later they were like on that day in March she sent 40, then you'd have a problem because you're talking about the same instance
Right.
and
Right.
changing the story. This is not an example of changing a singular instance of a story. Oh
Right.
boy. Okay. This is fine. Also, the other thing, I don't know. It's just like it's what you were going back to with the willful ignorance. Like, how much jank do you have to see before you decide I need to go? Right?
Yeah.
Like,
Yeah.
it's unreasonable.
I need to do something. At the very least, pick up the phone and call Planned Parenthood and be like, "Hey, do you see people anonymously?"
Oh yeah.
At the very least,
Instead, he did a weird Google search that wasn't even the right Google search to do.
months after the fact.
Crazy. In any case, the above facts show respondent did not violate ER 3.3 or any other rule, like any of them. Pick any of them. We're totally innocent. This is funny. Simply, oh no, because Ms. Owens changed her story. The standard of proof here is extremely high. The bar bears the burden to show not just Ms. Owens changed her story, but also that respondent knew the truth and intentionally offered false testimony and evidence to the court. I think to me, the bar should be that you knew that there was contradictory statements coming from your client, and you may not know what's true and what's not, but the fact that you're getting a bunch of contradictions should be a big red flag.
Yeah, and this is again just it's an incomplete statement of the law. The
Hmm.
bar bears the burden of show not just Miss Owens changed her story, but also that respondent knew the truth and intentionally offered false testimony. That's not the complete rule. The complete
Mhm.
rule is the bar bears the burden to show that either he knew or the facts could infer that the testimony was false. And he can't say that because that just really puts him in a bad situation.
Yeah, the one example could be false or the other one or both. And
Mhm.
if you have that signal coming at you, then you need to do something about it.
Yeah.
Okay, there's not a scintilla of admissible evidence to support a scintilla.
I do like that word, but unnecessary.
They're trying. They're trying. Okay, and then that's the end of this section because the next one is the unsuccessful appeal.
Yeah.
But I think we've been online for quite a while. Let me just check if there was. I think there were some other questions I might have had for you, so we
Yeah.
can wrap this up.
Yeah.
What is your take? Do you think he's doing this anti-SLAPP? The anti-SLAPP thing here. Do you think the strategy is really to win right here on the anti-SLAPP, or do you think it's more really about building some sort of appellate record?
Given that there is no precedent for it in
Mhm,
the bar discipline case,
mhm.
and how much he's already hurt his credibility with the court, with the PDJ, the anti-SLAPP to me is, he's doing it for the next appellate level, but he's also sort of screwed himself because, um, the whole reason he didn't file the anti-SLAPP motion right away was he wanted to get discovery on Mata. But what ended up happening was he waited so long and did so much damage that he actually closed the
Yeah,
door on that issue. So the
they ruled on it
strong,
already, yeah.
yeah, Jim Lee kind of just outplayed him. Like he, um, he can't, the strongest anti-SLAPP argument he had, the strongest anti-SLAPP issue he had was Judge Mata. That issue is moot right now. So what should happen is the Mata thing should get struck from this motion, and then it in his appeal he can raise anti-SLAPP on appeal.
Mhm.
But I don't know. It's gonna be. I'm pretty sure they will allow him to raise the anti-SLAPP issue for Mata on appeal, just from like a due process perspective. But if they wanted to be sticklers, you could say you didn't raise the anti-SLAPP issue before it
Oh,
was
yeah.
ruled on, so you're precluded from bringing it up on appeal. But I
I
don't think that
see.
the court's going to do that.
Oh, yeah, because it's more about, like, relitigating rather than bringing up a process issue. Yeah.
Right? Yeah, you'd be relitigating something without the court without the trial court considering it. The trial court has not
Yeah. That's a big
considered
risk.
whether.
Yeah.
Go ahead.
That's a big risk for him. Yeah, I agree. You're right, he's kinda shot himself in the foot on that one.
Yeah, it definitely did. Yeah.
Okay, yeah, all these arguments that, Woodnick did the same thing as me and you're not doing anything to him. I mean, how much weight do you give these things? Do you think it's a good
How do you mean?
just the selective enforcement argument,
I think
have
it's a
you
moot.
have you ever seen it work? Like, do you know of examples where it worked, and what do those look like? Do they look like this, or is it totally different, or
I think most lawyers who are trying to really help their clients are going to counsel their clients that pointing the finger at someone, like when you point one finger at someone, there's three pointing back at you. Like the best thing that he can do, okay, let me back up. The fact that other people did bad things
Yeah,
can go to mitigation. But what's
okay.
going to be stronger mitigation is acknowledgement that regardless of what anyone else has done, what you did was, if he is found to have violated these ethical rules based on that conduct, which he hasn't been yet. But the strongest thing that you can do in that situation is say, despite what other people have, like the way I would frame it is A, B, C, D, E people have done this and they didn't get punished. But despite their lack of punishment, I acknowledge and understand that what I did was wrong and I'm being punished for my conduct. And yes, I do think it's a little unfair because other people were treated differently, but I accept the responsibility that in my situation I violated it. That's what a good lawyer would tell you to do in this situation.
And what would that help?
Oh, acceptance of guilt is a mitigation factor.
Oh, okay. I mean, do you think this guy would actually do that? I just don't see that in his character.
That's the crazy thing is like when your whole career is on the line, like what do you have to lose? Like just like just say you were wrong. It's not like saying what I did was wrong. Like it's not like he's putting himself in criminal jeopardy by saying
Yeah.
that.
Yeah.
It's just purely an acknowledgement
Mhm.
that you violated the ethical rules. Like,
Mhm.
you can even prop that up with saying like, I did do this, I did violate these rules, but I was really just trying to help my client, and I know I overstepped my boundaries.
Yeah.
Like
No good
that is
yeah.
compelling acceptance of wrongdoing.
No good
But
deed goes unpunished. I think you're coming at it from a position of trying to save a career. I think this guy's trying to, like, sort of he's looking for an off-ramp or a way to go this it's really weird. I don't know what his goal in life is here because he's always blogging about how he wants to retire and dip out and
yeah.
disappear. But then on the other hand, he's like, "I'm gonna set all this stuff up to go to the Supreme Court." So I'm like, he seems to either wanna go all the way to the Supreme Court or dip out. And I'm like but just having a normal career where he can go back to, doing some, contract work for somebody, I don't think that's his goal.
And one thing I want to point out, like a big flaw in a lot of his arguments, even if he is writing this for the Supreme Court of the United States, the import of what he's saying is the all the ethical rules I've been charged with that I'm saying are unconstitutional because they violate my First Amendment rights. What he's asking the Supreme Court there to do, even though he hasn't put it in his argument, is he's asking the Supreme Court to find all of the ethical Arizona ethical rules that he's saying violate his First Amendment rights to find them unconstitutional. He's trying to he's basically asking the Supreme Court to find 5 or 6 different statutes
Yeah.
to be unconstitutional. Like, that is a very tall mountain to climb.
Yeah.
And he hasn't even framed the issue that way.
Mm. For sure, for sure. Yeah, so I'm not really sure what all the goals are here because if you really wanted to dip out, he could have taken that, what was it, 6 months and a day deal,
Yeah.
and
I mean,
ye
6 months in a
ye
d well, the reason he's not gonna do that is because he would have to redo his character and fitness exam, and
for
Lord
Arizona,
yeah, yeah.
but he wants to move. Why does he care about Arizona?
I think the reason he's probably fighting this so hard in Arizona is he knows that California will pull his ticket. Because the only requirement for California like, California is gonna enforce another jurisdiction's, discipline. The only way they won't do it is if there's 2 reasons, one of them doesn't apply here, the other reason is you were denied due process. And,
Mm,
like, what David and Laura just don't get is, like, they get so much more process than a lot of people,
yeah.
especially people without resources.
Mhm.
They have gotten all the process. And that's why you see the PDJ being so um you know, willing to entertain his bullshit for lack of a better word because they're trying to ensure that these people do get due process.
Right.
So I think the reason he's fighting this so hard is because he knows California's gonna pull his ticket, and then he really won't be
Mm.
able to file lawsuits as an esquire.
Oh, dear. Okay, oh my gosh.
I'm looking at chat too right now. If you guys have any
Yeah,
questions
are there any?
before we wrap
Yeah,
up.
we're trying to wrap it up. There's just about the Judge Matta order. You know, they have this. I don't know if you've looked at this Marshall versus Yagman that they're
Mm.
talking about. Um, the distinction between punishing false statements made recklessly versus true statements made recklessly is the sharpest legal issue in the filing. The claim the PDJ created a new category of unprotected speech is its
Oh
most
yeah,
consequential argument for appeal. You have thoughts on this? Since the
yeah.
Mata matter was our number one, even though it doesn't really relate to the anti-SLAPP topic for tonight.
Yeah, I'm not sure if this was the exact case, but there was a case that talked about a lawyer made public statements that the judge was anti Semitic because he sanctioned lots of Jewish lawyers, and that the judge was inherently biased against Jewish lawyers because of his conduct. And so the statement, the judge's bias, that statement was was like they were going to discipline him for that statement. And his argument was, look, there's this evidence that he has sanctioned more Jewish lawyers than non-Jewish lawyers. So that underlying statement was true. And so his statement of opinion at the end that the judge, well, it's really opinion and fact, but the statement of, in his belief, fact that the judge was biased, it wasn't unreasonable for, it wasn't knowingly false because the underlying statements were true. Like, if I say when I walked outside, the ground was wet, so it rained yesterday. Like, well, the sprinkler may have been on, but the fact
Right.
that the ground was wet is true.
Correct.
So maybe it did rain, maybe the sprinkler turned on,
Mhm.
but because the underlying facts are true, then the statement, even if it's not true, is not sanctionable. That's how I interpreted that case. Now, applying that to David, this is where we get into the inference on inference. He's saying the only objectively true fact informing his opinion that Mata is biased and conducted her own research, the only objectively true fact is that, as far as we know, in the record, the close on Sunday
Mhm.
never appeared.
Right.
So that is his pinky hold into that argument. However, it's a moot point because it's already been ruled on.
Yeah.
Um, but it could be raised in
Yeah.
appeal. It could be raised on appeal, I would say. Um,
Hmm.
but then there's a standard. Oh, okay, yeah. It would be raised on appeal, and it's reviewed de novo. And so, in his appellate brief, he can raise the fact that his statement was based on an underlying true fact. Um, but the problem is that that is not the only fact that he cited as the basis for his statement that Mata lied or Mata made things up. He also said Laura told him that Judge Howe said things or Attorney Howe said things. You know, there are multiple other underlying facts that he used to inform his statement about Mata, and those other underlying facts are not objectively true.
Mhm.
So it's there's a scintilla of evidence that his defamatory statements about Judge Mata were based on a underlying true fact.
Yeah, he's got one cornerstone,
One, yeah,
and then
he's
the
got
rest
one.
is all just speculation.
Exactly, and then
Um,
then you play the measuring game.
yeah, like how far Yeah, how far can you go based on that one cornerstone, and did he go too far? I mean, I is it becomes one of these subjective things. We have a few questions from
Oh yeah.
the, do you really think California will pull his card?
Yeah, I do.
Okay.
I do.
I mean, I think there's a good chance if things don't go well for him in Arizona. That to me, that really puts it in there. Here's one. Does Jingers have a leg to stand on when it comes to his allegations against Judge Mata? That's kind of what we were just discussing, but like, um,
Based on Jim Lee's filings, no, because Mata said she didn't view any social media posts related to it.
mhm.
She didn't talk to her dad about the case in any substantive way. So no, I mean, didn't Judge Mata also say she'd be happy to issue an amended ruling? I saw that somewhere. Um,
Yeah, and I mean, that goes to my point, right? I mean, I think she should have just done that anyway from the beginning, because it's like if you put some stuff and you're like, "Oh, maybe there was something when she was taking judicial notice of another case or something, or she had heard about Planned Parenthoods from another case and confused two things." Like, we just don't know, right? But obviously, once the ruling came out, everybody's talking about this, and at that point, it's like, okay, why not just amend this thing? Because in my opinion, whether or not Planned Parenthood LA is open on Sunday or closed on Sunday does not change anything in the ruling. Like, you could run two universes and have one where the place is open and one where the place is closed. The ruling's going to be the same.
So I was thinking about this in a slightly different context, but my conclusion applies to what you just said as well.
Mhm.
I was thinking about in the anti-SLAPP context, there's no precedent for anti-SLAPP applying to bar discipline cases. So um, I was thinking, like, why doesn't the PGJ just say, "Hey, I don't know what to do here," and before David can do any of his bullshit, because I'm always thinking like how to stop David from just talking. Um, like, why can't she just send it to the Arizona Supreme Court and be like, "Hey, point of first impression, I don't want to touch this. Can you rule on it?" And so I did a little bit of research to see if judges can do that in Arizona. In my jurisdiction, you can. In Arizona, you can't. What could happen would be Jim Lee could file what's called a special action
Mhm.
and say to the Supreme Court, "Hey, this anti-SLAPP thing, it's a matter of first impression. Can you please rule on it so we can move forward with the rest of the case?" But and this is where my conclusion comes in. The reason I don't think Jim would do that is because it kind of signals to the judge that you don't think that she's going to get it right. And in the same way that I think if Mata were to have revised her ruling because David had a hissy fit, it sort of undercuts her own credibility.
Mm.
And
Mhm.
so I do think that her offering that on the back end is sort of realizing like, dang, I should have just done this to begin with. I could have saved myself a big headache. But
Maybe not.
in the moment, yeah, probably not. In the moment, though, I think if she's thinking, I don't want to seem like I'm like I bend to threats
Mhm.
or that I'm going to be a judge who is, quick to listen to anyone's half-cocked, complaints about a non-material issue, and I'm just going to be a judge. So I, c-
Yeah, don't feed the trolls, right?
yeah. So I think the same reason why Jim shouldn't bring it as a special action is
Mhm.
because it harms the credibility of the PDJ in the eyes of the legal community, and
I
in the
see,
same
yeah.
way that Mata probably didn't want to amend her original ruling because it undermines the credibility in her office.
Yeah, yeah. There's a whole, like, process of doing business aspect here,
Just
which
optics.
I I look at it through this lens of, like, writing technical documents and specifications, and I always want everything to be perfect,
Yeah.
but this is a different domain, and those same ideas maybe not apply. Okay.
And my training is as in-house counsel, so I'm always thinking what's the law first and then what's business and then what's optics.
Mhm. Does the Sunday thing even matter if LO's answer was a lie and DG should have known? I mean, number one, I don't think the Sunday thing matters.
It
Um,
yeah, it only matters in terms of what David said about it.
yeah, I mean, in terms of this bar complaint issue, it's more about the meta issues about it, not the substantive issues about it. It's right. It's like, did Gingras have enough contradictory information from his client to warrant having he should have done some behaved differently as a lawyer, so the bar needs to sanction him.
Yeah, I mean, Owens v. Echard is done. Like,
Yeah.
pending something extraordinary, it's done.
Text packet says, "Am I the only person? What do you think about this letterhead on the side of the document? Is it? It's.
Yeah, I
I
don't know
mean, I
why.
don't. Seems fine to me, but I don't know what all the rules are.
Yeah, a lot of law firms will do that. Yeah, I personally find it distracting,
Hmm.
um, but a lot of law firms will do that.
Okay,
It is
very
weird.
good.
Mhm.
And we're all sitting here saying, "What? Can they just sanction this Gingras guy already? And he's such a troublemaker." Gave Reality Steve such a hard time, but he has at least one supporter tonight.
That's
$2
right.
from Lethal Lauren, justice for David. So he should know he has at least one supporter out there who's willing to part with $2 on his behalf. Oh my gosh, guys.
And I'll just give a
That's where we
PSA to
are.
people who are interacting with David. Like, he is not all, in my opinion, a truthful person, and he, in my opinion, can be very manipulative. So, like, don't tap the glass. Like, it's not worth it. The
Yeah.
PDJ is going to rule on a lot of these things, and we're going to get a clear answer to these things. Relying on an unreliable narrator's answers is not smart. It's also not healthy to get in that headspace, and it's really none of our business.
Yeah. I mean, we can be involved in the case as observers just by reading these court documents. So
Yeah.
to me, that's good enough.
Yeah.
Rob asks, if he is found guilty in the DUI case, how will that impact his bar status?
Great question, Rob. There is already a pending complaint with the that Jim Lee has all drafted up and sitting on the back burner related to the DUI.
Oh no.
So as soon as the DUI is resolved, there will be a brand spanking new case with David Gingras versus the Arizona Bar on his DUI.
This is your prediction.
No, this is what Jim said in an
Oh.
email to David.
Oh, okay. Oh boy. So that is a separate action from the bar predicated on the outcome of the DUI case. Is that correct?
Correct. That's exactly.
Oh dear. Okay. So it's a big impact, Rob. There you go. Okay,
I don't
great
think David's
question.
leaving anytime soon.
Oh boy. Trouble,
I mean,
trouble.
unless, I don't see any reason why Jim would drop it, because David has already indicated he's going to go all the way to SCOTUS. So if I'm Jim, I'm hedging my bets, and I'm going to I'm not going to say, oh, we got him, it'll work itself out on these 6 complaints. I'm not going to bother with the DUI complaint. I think it's in the public's best interest to litigate every single one of these.
Yeah. All right. All right. I think that's all I want to do. I'm pretty tired. So
Yeah, my eyes are closing.
Patrick, do you have any other final words for the stream, or is that a wrap?
I'm definitely hitting David fatigue because of the volume of documents that he has been providing. But what keeps me going is the fact that that's what he's counting on.
Mhm.
So I will continue to be around to have like more of these conversations, and continue to hold him accountable for just horrendous lawyering and human behavior.
Yeah, he definitely deserves, or he needs to apologize to certain individuals, uh, like Dave Neal's family, and many others, in my opinion.
And to not make homophobic comments, like,
Yeah.
it's
I
Yeah.
mean, you know, I think at one point, with the help of the Discord, I had accumulated a list of about 26 or 27 things that I sort of found that he did over the course of this case to be very distasteful.
Mm.
And it's like, look, at this point, it's over 2 dozen things that he should be apologizing for. Ah, where do you go from there? I don't know. But, guys, if you've stuck around this long, thanks for hanging out. Thanks
Yeah,
for the
thanks,
great
guys.
questions. And we will have Patrick back again, to go over more of these things as the bar case progresses or the DUI case progresses, and we will go from there. And eventually, we'll get to the criminal case too for the, Arizona versus Owens. So thanks, guys. Thanks, Patrick.
Thanks,
And
guys.
everybody have a good evening. I can find the end stream button here.